in the previous sessions, the report was submitted to government. In particular, His Excellency, the Vice President, the Honorable Minister for Finance and Economic Affairs, Honorable Attorney General and Minister for Justice, the Honorable Minister for Interior, and the Honorable Minister for Petroleum and Energy considerations and reply as per Order 100 of the Standing Orders of the National Assembly. Accordingly, honorable members, the Honorable Minister for Finance and Economic Affairs is scheduled today for reply to report on behalf of the government. May I now invite the Honorable Minister for Finance and Economic Affairs to take the podium and make his statement.
Most honorable Speaker.
Honorable Minister. Honorable members, let me acknowledge the presence amongst our midst here of the Honorable Minister for Fisheries, Water Resources, the Honorable Minister for Information, the Honorable Attorney General and Minister of Justice, and the Honorable Chief of Staff. You are most welcome. We recognize your presence. Somebody, pardon?
Hello. Motion.
Lower Salon.
Honorable Speaker. Motion without notice, orders 53E. Honorable Speaker, accordance with the orders 53E and 68(2) of the standing orders, I rise to move a motion that the bill entitled Judicial Officials Conditions of Services Bill 2025 commit to the Committee of the Whole House.
What he is doing, what he is saying is, I will have waited for a while, but nonetheless, a motion can come up at any time. And he is moving a motion that the Judicial Services Bill, when it comes, be committed to the whole House. Any seconder? On Jara Central?
Thank you, Honorable Speaker. I rise to second the motion.
Honorable members, it's been moved and seconded that the Judicial Services Bill be committed to the Committee of the Whole House. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. Honorable member, I think it's for Yebinta. You don't tell me no. There's a process. Honorable, please, when I'm talking. You know, I've had your ear, nose, and eye. I have made a decision. If you feel it is not correct, just go back to, as you said, division. And then we count.
Yes, but Honorable Speaker,
Honorable,
when you say I said no, I have the right to say no.
Honorable, I don't give you the floor. Don't talk, please. So, please, clerk, get ready. Those in favor of the motion, please raise your tags. Those in favor, raise your tags up so that it could be seen. Have you got it? Now you can put it down. Those against, raise your tags. Have you got it? Okay. Abstentions. Those who are abstaining, raise your tags. Abstentions? Honorable members, the results. Those in favor, ayes 2626. Those not in favor, sorry, those not in favor, noes 13. Abstentions 0. So the ayes have it. Honorable members, I now invite the Honorable Minister for Finance and Economic Affairs to take the podium and make his statement. Honorable Minister, please. He is out? Pardon? Honorable Minister, you can go ahead.
Okay. Honorable Speaker, please allow me to upload the file. Honorable Speaker, apologies for the hiccups. And as good morning, Honorable Speaker and august members of the National Assembly. I hereby deliver the report of the Parliamentary Inquiry Report into the importation and sale of 36,935,614 metric tons of petroleum products valued at $30 million. And housekeeping, I am under the weather, so my voice is not in its best form. The government of the Gambia received the report of the National Assembly on the above caption letter, reference ME43/100-02X/164, dated 18th of July 2025, in respect of findings, recommendations, and resolutions of the joint committees of FPAC and PEC, in accordance with Section 109/2 AB and 3 ABC of the 1997 Constitution. Committees may be established and or appointed to investigate or inquire into the activities or administration of ministers or departments of government and any matter of public importance, and such investigation or inquiry may extend to making proposals for legislation. Even though the Joint Committee, having conducted an exhaustive inquiry pursuant to its mandate, found that the matters under investigation, that is, allegations of bribery, money laundering, and tax evasion by Apogee FZC and Creed Energy Limited and Ultimate Page Logistics on the sale of petroleum products worth 36,953,614 metric tons, valued at $30 million could not be established. The government acknowledges that the inquiry revelations relating to serious governance and regulatory failures, pervasive non-compliance with financial, tax, and corporate laws, and a troubling disregard to due process by both the public institutions and private entities involved in the transactions. They observed that discovery of regulatory breaches, collusions, omissions, or commissions pose a significant risk to public interest and a dent to our reputable public finance governance environment. As a result of this outcome, the government's comprehensive approach is intended not only to inform the National Assembly, but also to demonstrate the government's commitment to upholding good governance, enhance governance systems and institutions, and strong will to enforce the laws and regulations of the management of national resources. To that end, the government welcomes the work of the Parliamentary Committee and have taken note of its recommended reforms, stricter regulatory reform frameworks, and urgency to enhance interagency coordination to prevent the recurrence of such malpractices. As such, the government is committed to taking decisive actions towards addressing identified anomalies. We now submit herewith the response of the government to the National Assembly Authority for consideration, information, and necessary actions. And we now delve into the report proper, which is labeled Government Response to the Parliamentary Inquiry Report into the importation and sale of 36,935,614 metric tons of petroleum products valued at $30 million. Introduction. This report presents the consolidated official response of the government of the Gambia to the findings, resolutions, and recommendations issued by the National Assembly Joint Committee of the Finance and Public Accounts Committee, FPAC, and the Public Enterprise Committee, PEC, in relation to the parliamentary inquiry into the importation and sale of 36,953,614 metric tons of petroleum products. In line with the Assembly's resolution, all relevant institutions and agencies were formally invited to submit clarifications, factual updates, and details of remedial measures taken or planned. These submissions were coordinated and compiled by the government committee to provide a unified and coherent response to the inquiry's conclusions and recommendations. To ensure transparency and accountability, the report is organized by the responsible institution. For each institution, the relevant recommendations from the inquiries are outlined, followed by the institution's formal response. Where applicable, this includes a summary of corrective actions already undertaken, ongoing reforms, and planned policy or regulatory interventions aimed at addressing the specific issues identified in the inquiry report. Even though the Joint Committee, having conducted an exhaustive inquiry pursuant to its mandate, found that the matters under investigation, that is, allegations of bribery, money laundering, and tax evasion by Apogee FZC, Creed Energy Limited, and Ultimate Page Logistics on the sale of petroleum products worth 36,953,614 metric tons, valued at $30 million, could not be established. This is the conclusion from the report proper. However, the government acknowledged that The inquiry revealed serious governance and regulatory failures, pervasive non-compliance with financial, tax, and corporate laws, and a troubling disregard for the process by both public institutions and private entities involved in the transaction. The observed discovery of regulatory breaches, possible collusion, omission, or commission, which posed a significant risk to public interest and a dent to our reputable public finance governance environment. As a result of this outcome, the government's comprehensive approach is intended not only to inform the National Assembly, but also to demonstrate government's commitment to upholding good governance, enhance government systems and institutions, and strong will to enforce the laws and regulations in the management of national resources. To that end, the government welcomes the work of the Parliamentary Committee and have taken note of the recommended reforms, stricter regulatory frameworks, and the urgency to enhance interagency coordination to prevent occurrence of such bad practices. As such, the government is committed to taking decisive action towards addressing identified anomalies. 1. Government response and remedial measures. A. Office of the President and the Vice President. The committee made the following recommendation on page 81. 1. Recommendation, Vice President to establish an interagency committee among key institutions to issue quarterly updates to the executive and for further action. Response. The committee is established, coordinated by the Office of the Chief of Staff, to monitor and update the executive on the implementation of agreed actions. On page 81, the committee made the following recommendations too. The executive should administratively hold to account the head of the police, the Gambia Ports Authority, and the Central Bank of the Gambia for their inaction following receipt of intelligence report from the FIU. Response. The Central Bank of the Gambia and the Gambia Police Force acted following the receipt of intelligence report from the FIU. The Central Bank conducted a prudential site visit to Access Bank and Eco Banks in relation to Creed Energy and Ultimate Bridge Logistics to assess the potential regulatory and prudential breaches. A confidential report on that visit to the banks was shared with the Assembly. The police commenced an investigation into the activities of Apogee FZZ, Creed Energy, and Ultimate Bridge Logistics for potential violations of the Anti-Money Laundering CFT Act and other financial crimes. This was halted only when after the source of funds was established. With respect to the recommendation to hold the head of the Gambia Ports Authority to account, we fail to see a clear link between the FIU report and the GPA responsibility on matters of AML, CFT. On page 82, recommendation 3, the committee recommends the Assembly Cabinet immediately review all 3 purported policy letters. 4, the committee further recommends that all government policies should obtain cabinet approval and should be gazetted. Response. Ministers have the authority to issue policy directives that are deemed necessary in enhancing the operations of their sectors and at the same time not compromising the well-being of other stakeholders. In this instance, letter number 3, not compromising children. The procedure for formulating the national policy document is clearly stated in the National Policy Handbook, already adopted by Cabinet and henceforth guide policy making in the government, and such decisions are then gazetted. B, Office of Registrar of Companies. The committee made the following recommendation. 5, that a dedicated compliance and enforcement unit within the Registrar of Companies to ensure full compliance with the existing laws and regulations. Response. The ministry accepts this recommendation and will take steps to strengthen the existing inspectorate unit, transforming it into a dedicated compliance and enforcement unit. This unit will be tasked with ensuring continuous and effective enforcement of the provisions of the Companies Act and all other relevant laws, thereby promoting full compliance at all times. 6, strict enforcement of annual filing of returns as a condition for renewal and imposition of penalties for failure to comply. Response: the Ministry accepts this recommendation. The Registrar of Companies will henceforth issue notices to all registered companies before the end of each financial year, reminding them of their obligation to file annual returns in accordance with the law. Failure to comply within the stipulated time frame would result in the imposition of applicable sanctions. 7, the committee recommends verifiable proof of business premises at registration. Conduct fiscal verification within 30 days post-registration. Issue warnings to defaulters and strike of companies that fail to comply within a stipulated period. Response: the Ministry accepts this recommendation. The Registrar of Companies will ensure that all declared fiscal addresses are subject to verification. Fiscal verification will be conducted within 30 days of the registration, and appropriate enforcement actions will be taken against defaulters in line with the committee's recommendation. 8, establish an interagency compliance task force that includes the Registrar of Companies, the FIU, GRA, and PURA. Response: the Ministry fully supports the establishment of an interagency compliance task force comprising the Registrar of Companies, the Financial Intelligence Unit, the GRA, and PURA. We believe such a collaborative framework will enhance information sharing, improve regulatory oversight, and strengthen enforcement of compliance with applicable laws and regulations. 9, all new registrations and renewals should be subject to clearance from relevant authorities. Non-cooperative actors within these institutions who acted in breach to regulatory breakdowns must be identified and reported for administrative actions. Response: while the Ministry supports the proposal to subject all new registration and renewals to clearance from the relevant authorities, we note that implementation may be challenging as it will require confirming compliance with regulations administered by other institutions. Nevertheless, we remain committed to collaborating with the relevant authorities to the extent possible to support any initiative aimed at strengthening regulatory compliance. Whilst no known uncooperative actors are identified in your report, further inquiries require on our end if it so reveals any uncooperative and regulatory breaches will be subjected to administrative sanctions. On page 42, paragraphs 4 and 5 of the report, the committee recommended that 10, the Attorney General and Minister of Justice should initiate criminal investigations into RMOs for potential violation of AML, CFT Act, and other financial crimes. Response: the Ministry notes this recommendation and is of the opinion that the matter be referred to the police as the initiation of criminal investigation falls within their mandate. Once such investigations are concluded and a case file is submitted to our office, we will review the evidence and, where appropriate, proceed with the prosecution in accordance with the law. On page 83, paragraph 2 and 3 of the report, the committee recommended 11, that the Attorney General and Minister of Justice should constitute a special panel to further investigate the conduct of Officer Commanding Mr. Pa Ali Jawara in the investigation into the report of the Financial Intelligence Unit and report to the National Assembly within 90 days of tabling this report. 12, committee further recommends that the Attorney General and Minister of Justice constitute a special panel independent to investigate the procedure adopted by the police in the investigation of the STR report, that is suspicious transaction report, against Mr. Orimus, and report to the National Assembly within 90 days of tabling of this report. Response: The Minister of Justice notes this recommendation and will constitute a special panel to conduct both the investigation concerning Officer Commanding Mr. Pa Ali Jawara on the follow-up investigation of the FIU intelligence report, as well as that of Mr. Aremos regarding the procedure adopted by the police in the investigation of the STR report. On page 84, paragraphs 9 and 10, 13, all submissions made to the committee under oath by Mr. Yoro Jallo should be reviewed, and criminal perjury proceedings initiated against him by the Honorable Attorney General and Minister of Justice for deliberately misleading the Assembly. Response. The Minister of Justice notes this recommendation. Allegations of perjury falls within the investigative remit of the police. Accordingly, the matter should first be investigated by the Gambia Police first to establish whether sufficient evidence exists to support the allegation. Upon receipt of the investigation report and the supporting evidence, this ministry will review the case and, where appropriate, institute criminal proceedings in accordance with the law. 14, that Mr. Yoro, pending the review by the Minister of Justice, be sent on administrative leave. Response. The Minister of Justice notes this recommendation. Decisions regarding the administrative leave of Mr. Yoro Jallo fall within the purview of his employing authority. Accordingly, upon completion of our review and the filing of any necessary processes, we will advise his employers as appropriate. Sending Mr. Jallo on administrative leave pending the review or outcome for alleged perjury would not be necessary at this stage. On page 86, item 15, Registrar General's Office should immediately A, review the file of UBL Gambia Limited, including board resolution minutes to determine the accuracy of the declarations made at the point of declaration. B, establish stricter verification protocol for director appointments, including personal appearance or notarized consent by proposed directors. The Ministry Response of Justice has noted this recommendation and will institute necessary protocols. On page 86, paragraphs 1, 2, and 3, 16, the Honorable Attorney General, Minister of Justice should investigate UBL Gambia operations in line with the provisions of the Companies Act 2013 and institute prosecutions where necessary, are reported to the National Assembly within 90 days of the tabling of this report. Response. The Ministry acknowledges this recommendation and will, through the Registrar of Companies, review the operations of UBL Gambia to assess compliance with the provisions of Companies Act 2013. Where breaches are identified, appropriate enforcement action, including prosecution, will be undertaken in accordance with the law, and a report will be submitted to the National Assembly within the stipulated time frame. 17, the registrar should immediately present a petition to the High Court to compulsorily wind up UBL Gambia Limited. Response. The Ministry, through the Registrar of Companies, will assess the legal and factual basis for initiating compulsory winding up proceedings against UBL Gambia Limited under Companies Act 2013. Should sufficient grounds be established, the necessary petition will be filed before the High Court without delay. 18, the Attorney General should bar Mr. Okufo from acting as a director or an officer in any company operating in the Gambia. Where Mr. Okufo currently acts as a director, his directorship should be revoked immediately. Response. The Attorney General does not have the legal authority to unilaterally bar an individual from serving as a company director. Such action can only be taken in accordance with the provision of Companies Act 2013 and upon the order of a competent court. The Ministry will therefore review the matter, and where the evidence supports such action, will apply to the court for an order disqualifying Mr. Okufo from acting as a director or officer in any company operating in the Gambia. On page 87, paragraphs 1A and B, 19, Registrar General's Office should immediately commence proceedings to strike off Apoji Gambia Limited from companies registered pursuant to the Companies Act. For response, the Registrar General's Office will review the status of Apoji Gambia Limited to determine the compliance with the provisions of the Companies Act 2013. If the company is found to have contravened the Act or to meet the statutory grounds for striking off, the registrar will commence the necessary proceedings to have it removed from the company's register. B, report the matter to the Financial Intelligence Unit and PURA for any further regulatory or criminal investigation into Apoji Gambia establishment and use. Response. Following the conclusion of the review, the matter will be reported to the Financial Intelligence Unit and the Public Utilities Regulatory Authority for any further regulatory or criminal proceedings into the establishment and activities of Apoji Gambia Limited. I need tissue, please. Response. Following the conclusion of the review, the matter will be reported to the Financial Intelligence Unit and the PURA for any further regulatory or criminal investigation into the establishment and activities of Apoji Gambia Limited. On page 87, item 20, the Registrar General's FIU, Minister of Justice, should, 1, launch an inquiry into the true beneficial ownership of Creed Energy and whether Mr. Drame served as a proxy for foreign interests. The Minister of Justice, through the Registrar of Companies, agrees to and will collaborate with the Financial Intelligence Unit to conduct an inquiry into the true beneficial ownership of Creed Energy and determine whether Mr. Drame acted as a proxy for foreign interests in accordance with the Companies Act and other applicable laws. 2, require that all companies in regulated sectors disclose beneficial ownership details verified by identification, source of wealth, and role. Response. The Ministry of Justice, through the Registrar of Companies, recognizes the importance of obtaining and verifying beneficial ownership information for companies in regulated sectors. This process presents practical challenges, particularly where verification relies on information held by other regulatory bodies. Nevertheless, we will work in close collaboration with FIU, sector regulators, and other competent authorities to develop practical solutions. Where such solutions are established, we will require companies to provide beneficial ownership disclosures verified by proper identification, source of wealth, and role as recommended. On page 88, paragraph 4, item 21, Registrar General Pura, Minister of Justice, should declare Mr. Nana Koranteng and other foreign directors of Creed Energy ineligible to serve as director in any petroleum sector entity for a minimum of 5 years, subject to the findings of any ongoing investigations. Response. The Minister of Justice, through the Registrar of Companies, notes this recommendation. Any decision to declare Mr. Nana Koranteng or other foreign directors of Creed Energy ineligible to serve as directors in the petroleum sector entities must be guided by the outcome of our ongoing investigation and in accordance with the due process under the Companies Act and other applicable laws. So the investigation established grounds for disqualifications. The necessary legal steps will be taken to enforce such restrictions for the recommended period. On page 89, item 22, the committee recommended an amendment to the Companies Act to A, mandate that resignations of directors/ shareholders must be simultaneously filed with the registrar and relevant authorities, regulatory bodies such as PURA or FIU for petroleum sector companies. B, impose penalties for failure to notify resignations within 15 working days. require all banks to revalidate corporate signatories every 6 months against the registrar's updated records. B, the Minister of Justice notes this recommendation. On page 93, item 23, that the Attorney General initiate criminal investigation into Mr. Arimas and related parties for potential money laundering and financial crimes. The Ministry of Justice notes this recommendation as the conduct of criminal investigation is the responsibility of the police. We recommend the matter be formally referred to the Gambia Police Force for investigation into the alleged money laundering and related financial crimes involving Mr. Arimas and associated parties. Upon receipt of the investigation file, this ministry will review the evidence and where a prosecutable case is established, proceed with charges in accordance with anti-money laundering and other applicable laws. On page 94, item 24, that the Attorney General, Minister for Justice constitute a special panel to further investigate the conduct of Officer Commanding Mr. Pa Aliu Jawara in the investigation into the report of Financial Intelligence Unit and report to the National Assembly within 90 days of tabling this report. That the Attorney General, Minister of Justice constitute an independent special panel to investigate the procedure adopted by the police in the investigation of the STR report against Mr. Arimas and report to the National Assembly within 90 days of tabling of this report. Response, the ministry notes this recommendation and the Ministry of Justice will constitute a special panel to conduct both the investigations concerning Officer Commanding Mr. Pa Aliu Jawara into the report of the FIU and Mr. Arimas regarding the procedure adopted by the police in the investigation of STR report. On page 96, item 25, that the Attorney General initiates proceedings to wind up UBL Gambia Limited and prosecute its director, including Mr. Nana Akufo. The ministry, through the Registrar of Companies, will assess the legal and factual basis for initiating compulsory winding up proceedings against UBL Gambia Limited under the Companies Act 2013. Should sufficient grounds be established, the necessary petition will be filed before the High Court without delay. On page 96, general recommendations. 27, that the Attorney General initiate criminal proceedings against all persons found wanting as identified in the committee's report. Response, the Minister of Justice notes this recommendation. The initiation of criminal proceedings require the completion of a thorough investigation and submission of evidence by the relevant investigative authorities. Upon receipt of such investigation files, and where the evidence discloses a prima facie case, this ministry will take necessary steps to institute prosecution against all persons found culpable in accordance with the law. Financial Intelligence Unit recommendation. The committee made the following recommendation on page 82, item 28, that the National Assembly consider passing a comprehensive whistleblower protection act. Meanwhile, the FIU must operationalize its internal protocols to ensure anonymity and non-retaliation against its whistleblowers. The FIU response affirmed that it operationalized its internal protocols as required under Section 35 of the AML-CFT Act 2012, which provides for whistleblower anonymity and protection. On page 87, 29, the FIU and the Central Bank should A, trace all bank accounts opened in the name of UBL Gambia Limited with a forensic audit of inflows, outflows since inception. B, cross-reference beneficiary signatures and mandates with corporate resolutions submitted to the Registrar of Companies. C, provide a conclusive beneficial ownership report identifying all parties who benefited directly or indirectly from UBL Gambia Limited's transaction. Response, the matter is being referred to the Central Bank of the Gambia for necessary action. Item D, Ministry of Petroleum and Energy. The committee made the following recommendations on page 82. Item 30. The committee is of the view that The former Minister of Petroleum, Mr. Abdullahi Job, may have committed a misconduct in office and that the Assembly should initiate proceedings to censure him for his role in the purported policy MOP/GOP/PP/PP/002 as referenced in the letter dated 30th of October 2023 and interference into police investigation. Response. The government holds the view that the former Minister of Petroleum, Mr. Abdullahi Job, acted within his ministerial powers to issue the policy note reference in the letter dated 30th of October 2023. On page 86, GNPC should ensure strict due diligence for all petroleum transactions, including verification of vendor licensings and corporate registration status. GNPC is required to take disciplinary action against the officials responsible for approving contracts without verifying legal identities. GNPC's procurement policies should be amended to include mandatory licensing checks for all vendors, including cross-jurisdictional verification for foreign entities. Response. The recommendation has been noted and the above matters will be referred to GNPC board to institute the necessary protocols identified the officials who breach the verification protocols and take the necessary disciplinary actions. On page 86, item 34, the Ministries of Petroleum and Finance should jointly develop a national petroleum strategy aimed at expanding GNPC's market share to a significant proportion. Response. The government, through the policy directive, has already tasked GNPC to expand. This is one of their KPIs with the SOE commissions. The GNPC is expected to develop their strategy aimed at expanding their market share as per existing government policy directive. They have already developed 2 model stations and working on additional 2 stations. On page 90, item 35, the Petroleum Commission should regularly conduct a review of licensing, village allocations, duty waivers, and market behavior quarterly. Its findings should be submitted to the Minister of Petroleum. Response. The Petroleum Commission deals with upstream matters. Downstream related matters are regulated by PURA. It would be appropriate for PURA to assume this responsibility. On page 90, item 36, all village applications should be subject to competitive review. Any ministry official found complicit in supporting exclusivity deals must be subjected to administrative disciplinary measures. Ministry of Petroleum and Energy and Mines will work with PURA and GCCPC to develop a village allocation guidelines to address this issue. It can be monitored by a Petroleum Downstream Committee comprising key stakeholders. On page 90, 37, Minister of Trade and MOPI, Minister of Petroleum and Energy, in collaboration with FIU, should issue binding directives requiring that all fuel-related invoices must indicate the license consignee, the ownership chain, and the payment destination. A national due diligence protocol for OMCs dealing with foreign traders should be developed. Any OMC found operating without proper KYC checks, despite warning signs of proxy invoicing, should be fined and required to retain their procurement teams under the FIU supervision. Response. Minister of Petroleum and Energy will coordinate with the other stakeholders and PURA to ensure that this is included in the licensing terms and condition or other relevant documents. Gambia Police Force, that is item E. The committee made the following recommendations on page 83. The Attorney General, Minister of Justice should constitute a special panel to further investigate the conduct of Officer Commanding Mr. Pa Aliu Jawara into the investigation into the report of the Financial Intelligence Unit and report to the National Assembly within 19 days of tabling of this report. The committee further recommends that the Attorney General and Minister of Justice constitute a special independent panel to investigate procedure adopted by the police in the investigation of STR report against Mr. Orimos, a report to the National Assembly within 90 days of the tabling of this report. Response on MOJ recommendations on page 4 above. On page 90, 40, Ministry of Interior should be directed to establish a centralized case management system to track the progress of all investigation. The matter has been directed to the Ministry for consideration. Item F, Gambia Revenue Authority. The committee made the following recommendations. The GRA must establish proactive compliance mechanism for all newly registered companies with mandatory quarterly verification of filings and activity status. Response. GRA is currently working on automating all its business processes, including installing a web-based ITAS, that's Integrated Tax Administration System, that will facilitate e-filing, e-registration, and e-payments against others. This, when completed, will enhance tax filing compliance. On page 83, item 42, GRA should take all measures to recover the outstanding tax obligation of Creed and Ultimate Page Logistics in the sums of $8,576,716.08 butut and $12,296,923.81 respectively. Response: the assessed corporate tax for the two companies are best of judgment assessments as a result of failure to file a tax return. GRA will use information available to generate a tax assessment which may be disputed and initiate recovery where possible. On page 83, item 43, the committee recommends that GRA enhance the capacity of its existing unit to ensure that taxes are paid on time. This recommendation is noted. GAM Petroleum, item G. The committee made the following recommendation. 44, an independent criminal investigation should be conducted by the police into the conflict of interest and breach of fiduciary duties by the General Manager of GAM Petroleum. 45, the General Manager of GAM Petroleum be immediately suspended from office pending the outcome of the investigation. Should the investigation substantiate any criminal liability, prosecution should be initiated against him. Response: the relationship between traders, OMCs, and GAM Petroleum are defined in their ullage and storage agreements. GAM Petroleum holds the petroleum stock on behalf of traders. The police will initiate investigations as recommended into any conflict of interest and breach of agreements and fiduciary duties against the General Manager. Item 47, National Audit Office should conduct an audit exercise as regards the fairness in the allocation of ullage between January to December 2023 by GAM Petroleum and report to the National Assembly within 60 days. 48, GAM Petroleum should not enter into any agreement with Apogee Gambia Limited, and where any contract is entered into between GAM Petroleum and Apogee Limited, the said contract should be terminated immediately. 49, henceforth, GAM Petroleum should submit its account for audit by the Auditor General for further reporting to the National Assembly. Response: the matters raised will be referred to the National Audit Office and GAM Petroleum Board for necessary action. 50. State institutions such as Ministry of Finance, Social Security, Gambia Ports Authority, and GNPC should demand governance reforms in the operations of GAM Petroleum to provide public interest safeguards. The recommendations have been noted and will be referred to the GAM Petroleum Board for action. Item 51, all submissions made to the committee on the oath by Mr. Yoro Jallo should be reviewed and criminal perjury proceedings initiated against him by the Honorable Attorney General, Minister of Justice, for deliberately misleading the Assembly. See response on Minister of Justice recommendation on page 4 above. Item 52, Mr. Yoro Jallo should, during the pendency of the review by the Minister of Justice, be sent on administrative leave. See response, Minister of Justice recommendation on item page 4 above. Item H, Minister of Finance and Economic Affairs. The committee made the following recommendations. 53, ministries should publish detailed monthly reports on the pricing breakdowns, including supplier premium and exchange rate assumptions. A public-facing online portal should be created to display all fuel price components to foster transparency. Response: the monthly fuel pricing mechanism conforms to foster transparency because it is determined by a multi-stakeholder committee and are also guided by properly defined parameters. 55, Ministry of Finance should collaborate with Ministry of Petroleum to develop a binding code of conduct for equitable village allocation. Response, Ministry of Energy and Petroleum will work with PURA and GCCPC to develop village allocation guidelines. Meanwhile, Ministry of Petroleum will compel the depot to allocate village on an equitable and first come, first served basis. Item 56, Ministry of Finance should ensure all joint policies involving fiscal or economic implications pass through the cabinet scrutiny. The Ministry of Finance typically determines all fiscal and economic policies and is often approved by cabinet. On page 90, Ministry of Finance, item 57, Ministry of Finance should propose the executive for the restoration of the importation plan requirements as a condition for village allocation. This would ensure planned imports match national assumptions, consumption needs, and prevent hoarding or speculative practice. Village allocation and importation plan are matters of operations for fuel depot companies. Central Bank of the Gambia. The committee made the following recommendation. Item 58, the Central Bank of the Gambia should issue regulations prohibiting sub-accounts managed by third parties and foreign entities without local registration. Banks found in breach, Access Bank and Eco Bank should be subject to punitive monetary penalties. Response, the Central Bank will be conducting a special audit on sub-accounts and foreign currency transactions. Thereafter, and in collaboration with FIU, the KYC regulations will be updated to explicitly cover operations of sub-accounts. In particular, the AML CFT guidelines issued jointly by the Central Bank and FIU in 2016 will be reviewed if found necessary. On page 85, item 59, the Central Bank should consider imposing appropriate sanctions on Access Bank and...
Honorable Speaker, I just have an observation. Member for Nyamina Danku. Honorable Speaker, according to our order paper, the time allotted for this business is 1 hour, comprising the presentation of the minister and our contribution. But the minister almost took us 1 hour now. So I don't know what will be.
Honorable, we will deal with that. Yes, Honorable Minister, can you continue?
59, the Central Bank should consider imposing appropriate sanctions on Access Bank Limited and Eco Bank Limited for breaching prudential risk guidelines. Following the prudential visits to Access Bank Gambia Limited and Eco Bank Gambia Limited, the Central Bank has imposed regulatory fines on the two banks in January 2025. On page 85, item 60, all commercial banks in breach of prudential risk guidelines issued by the Central Bank should be penalized. In accordance with the Banking Act, a special audit should be conducted to ensure no similar arrangement exists in our banking system. Recommendation. This recommendation is noted, and we assure that the imposition of penalties as well as other punitive sanctions will be maintained. The Central Bank has in place a robust sanction regime which specifies the applicable monetary and administrative sanctions applicable to varying breaches of prudential guidelines. We wish to confirm that the Central Bank will be carrying out a special audit on foreign currency transactions and operations of sub-accounts to ensure no similar arrangement exists in our banking system. Item 61, the Central Bank should enforce tighter scrutiny over foreign currency transactions involving large volumes. Institutions found facilitating such outflows without adequate vetting should face foreign exchange restrictions and fines. Item response, Central Bank has issued guidelines on foreign currency operations which requires financial institutions to ensure purpose of foreign currency transactions are well documented. The Central Bank will continue to ensure tighter enforcement of these regulations and apply sanctions when breaches are observed or subject such guidelines to further review as and when necessary. 62, Monetary Policy Committee should be empowered to review and control sector-specific FX exposures. Response. With regards to scrutiny over foreign currency transactions involving large volumes, arrangements are already in place for financial institutions to report their foreign currency net positions, which is a supervisory tool to prevent excessive exposure on their balance sheet. This data is presented to the Monetary Policy Committee quarterly meetings for review and discussion. Financial institutions are also required to enforce the provisions of the Anti-Money Laundering Act by reporting suspicious transactions to the Financial Intelligence Unit, regardless of the size of the transaction. This is against the backdrop of a liberalized capital account in the Gambia. Furthermore, as part of the monitoring the foreign currency outflows, the central bank in July 2023 directed that all banks must direct all their foreign currency shipments to the central bank, which are subject to thorough screening to prevent outflows of illicit funds into the nostro account of commercial banks. Item 63, the FIU and the Central Bank of the Gambia should trace all bank accounts opened in the name of UBL Gambia Limited with a forensic audit of inflows, outflows since inception. B, cross-reference beneficial signatures mandate with corporate resolutions submitted to Register of Companies. C, provide a conclusive beneficial ownership report identifying all parties who benefited directly or indirectly from UBL Gambia Limited transaction. Response, this recommendation is noted and Central Bank will collaborate with FIU to further review the UBL corporate and financial activities. Item 64, Central Bank should initiate internal and criminal investigations into potential collusions and regulatory breaches by Access Bank officials. Where complicity is confirmed, individual officers must be prosecuted under anti-money laundering and financial crime statutes. Response, refer to actions by Office of the President. J, PURA, that's the Public Utility Regulatory Authority. On 65, all existing contractual agreements between GAM Petroleum and OMC should be reviewed by PURA immediately to ensure transparent and equitable ullage allocation framework. Furthermore, all contractual agreements between GAM Petroleum and OMC should be approved and monitored by PURA in accordance with its regulations. Response, PURA will be tasked by Ministry of Petroleum and Energy to review all existing contractual agreements. Ministry of Petroleum and Energy will monitor through the Petroleum Downstream Steering Committee to ensure the recommendations are implemented. Item 66, PURA should be more prudent in pursuing findings made against entities and institutions under their purview and take enforcement of fines and recovery measures more seriously. Response, this recommendation is noted. Item 67, Petroleum Products Act and PURA Act should be reviewed to establish a dedicated upstream regulator or expand PURA's oversight to upstream operations. This will close the loophole that allows international traders to act without regulatory oversight. Response, the relevant acts will be reviewed to align with present realities. We considering moving the downstream regulations from PURA to the Petroleum Commission to have a single regulator focus on the petroleum sector. It's important to note that there is already an upstream regulator established at the Petroleum Commission. PURA regulates downstream, upstream matters are handled by Petroleum Commission, and it involves the exploration, development, and production of oil and gas resources. Downstream matters are handled by PURA, which involves the importation and marketing of refined products. It is also important to highlight that international traders are not subject to any form of local regulation in line with international best practice. Item 68, the government should consider immediately establishing a national petroleum testing laboratory. Response, a fully functional national petroleum testing laboratory is being established and a contract already signed with SICPA. Item 69, until its establishment, PURA must issue quarterly reports on the foreign testing expenditures and validation of petroleum products being imported into the country to the Ministry of Petroleum and Energy. 70, PURA must develop a proactive surveillance and compliance audit schedule as regards the operations of OMCs, importation of petroleum products, and connected matters. Failure to implement this system within 6 months should result in administrative disciplinary actions being instituted against its officials. All testing procedures are captured in PURA accounts and are properly audited. With respect to outcome of the test, they are reported and shared with OMCs and traders upon request to the ministry. Further, inspection, testing, and rigorous surveillance are already in place. PURA strictly enforces the license conditions for the operations of OMCs, and breaches are dealt with under the law. Item 71, PURA in collaboration with the Ministry of Petroleum should, 1, amend the petroleum licensing regulations to impose minimum capital, infrastructure, and staff requirements for companies applying for A, import license, B, depot village access, and C, fuel sales permit. Response. There are terms and conditions in place. However, the Ministry of Energy will work on improving the issues identified. The Ministry will review the regulations to include in the recommendations. Item 72, special inquiries should be conducted by the Petroleum Commission and PURA to establish the basis upon which privileges are granted exclusively to Apogee FZC. PURA will be tasked to conduct the inquiry as competent regulator for downstream. Item 73, PURA must put in place the regulatory conditions requiring all petroleum depots to vet international traders using a minimum due diligence checklist prior to granting license fees. The petroleum depots operate based on PURA's authorization, that is the license, and their relationship with traders.
Honorable Minister,
Yes.
I don't know, honorable members, from my copy, it stopped at 32, page 32, what he is reading on 91 on page, it's not with me. Do you have it? Hey. Yeah, it looks like, hey, just come.
Can I proceed? Thank you, Honorable Speaker. It looks like point. Okay, you'll be briefed.
Honorable Minister, you are on number 73. Am I right? From your report, where does it end? Which number?
Binding issue, because those are the last parts of the report before the conclusion. Yes.
Honorable members, we stopped at page 73. If you look at your report, and it's up to 76. We have 3 more points. Let's listen to it. Let's listen to him. Yes, go ahead, Honorable Minister.
Response, the petroleum depots operate based on PURA's authorization. That's the license, and their relationship with the traders are defined by the ULH. Item K, that is 74, which deals with the Gambia Competition and Consumer Protection Commission. I-74, on page 88, these are responded previously on the earlier sections, but I will just read the recommendations. 74 reads, GCCPC and FIU should review all transactions involving Creed Energy, Apogee, and UBL Ghana from 2022 to 2024. 75, GCCPC and FIU should determine whether Creed Energy acted as an unauthorized intermediary, potentially enabling price manipulation or tax evasion. 76, where misconduct is established, impose fines and refer matters for criminal prosecution. The responses to items 74, 75, 76 are as follows. The matter is referred to GCCPC and FIU for necessary action. In conclusion, Mr. Speaker, the government has fully considered all the recommendations contained in the report and affirmed its full commitment to implementing them in a manner consistent with the specific facts, legal standards, and institutional mandate involved. Each matter will be addressed on its own merits, whether through the initiation of criminal proceedings following due investigation, the exercise of regulatory authority on the existing laws, or collaboration with relevant oversight bodies to ensure compliance. In all instances, the government will act with diligence, transparency, and strict adherence to the rule of law to ensure the effective enforcement of the report's recommendations and restoration of public trust in our governance institutions. That concludes the report response, and I submit. Thank you.
Thank you very much, Honorable Minister for Finance and Economic Affairs. Honorable members, I instruct the Office of the Clerk to make sure they have paragraph 73 to 76 missing and the concluding remarks to get them and circulate it to all honorable members. Your report should be complete. Honorable members, pursuant to Order 48.6 of the Standing Orders, and here I quote, after the statement has been delivered in the Assembly, a period of questions on the statement, which shall last no more than 1 hour, may then ensue. The Speaker shall determine the period taking into consideration the content of the statement, the number of members wishing to ask questions, and the pressure of other businesses. I will now invite honorable members to submit their names who want to ask questions or to contribute on the statement, minister's statement, and the fears of the honorable member for Nyamina Dankunku. The honorable minister has taken almost the entire hour, and we will open it up for members depending on the number of people who want to participate. We will open it up for members to contribute, to do their contributions or ask their questions. So, honorable members, you can raise your tags and have your names written. Yeah. Honorable members, do you have anybody contributing? That's all? Please write that. If you don't write your names, we have exhausted the time. We will not wait and then be asking and you'll be putting your tax up. You will not take it. Honorable members, we have about 8. So I will do my best to give each of them a chance to do their contributions or ask questions. Let's make maximum use of the time. I now invite the Honorable Member for Latrikunda Sabiji.
Thank you very much, Honorable Speaker. And I thank the Honorable Minister for this response. Honorable Minister, Honorable Speaker, rather, what I want to establish, when we select or institute select committees here for special, on a special assignment, when they write to the government, are we writing to government by way of directive, that is to act? Because what I realize here is they have this discretion to act on certain things and have discretion to refer it to a certain ministry. Because my understanding is government is an infrastructure. When we direct questions to particular ministry, I don't, as far as our special inquiries are concerned, I don't know why do they need to send it to another ministry so that we can wait for the reply from that particular ministry. That's not the case. I think they should say government is an infrastructure. As I said, when we tell them to do something or respond to certain things, they should not be referring them to one another. They should just respond to it as to make our work very, very easy.
Can you give an example?
The example, if you look at the report where it will say it refers to, we refer the particular thing to DNPC, we refer it to Interior for special those kind of special investigations. That's what I want to say. If the Ministry of Finance is part of the government, they should be able to respond to these questions. That is by soliciting answers from those ministries, so that when they come here, we don't need to waste time. Honorable Speaker.
Honorable, let's get that clear.
Yes.
I think when they make reference to the office of the IGP, they're saying that is the prosecuting agency. Those are the people who do the investigation. Now, with whatever revelations we have, whatever investigation we have done, it must go through that process. Now, due process now. So the police will go and do the investigations, establish the facts, send the facts to the office of the AG, and then it's established, and then there are enough grounds, and the prosecution takes place. That's a process.
Okay, thank you.
Yes.
Thank you very much, Honorable Speaker, for that explanation. Now, if you look at the recommendations against the register of the company, for me, I don't know why this recommendation, but there are laws, and the position of the law is very clear as far as the mandate and the responsibility of the register of companies is concerned.
To the page.
That was just a shorthand note, actually. I think that should come. I think that was just a shorthand note I took separately. Let me go back to the.
If you can't remember the page, just continue.
No, I can't remember the page, actually. But
okay, continue.
So, as I said, the responsibility of the register of the company is very clear, and the position of the law is very clear as far as these responsibilities are concerned. I don't know why the National Assembly, when the committee went further to recommend, but for me, it's just negligence. If you don't do your job, you are just being liable for negligence. And the National Assembly should recommend as per that. So I don't know why those kind of recommendations, which are not very, very clear.
Honorable, these recommendations emanate from you.
That's what I'm talking about.
Now, you cannot question that.
Okay, thank you.
You cannot put that question to who?
And also, the interagency compliance tax, that will also take back to what I said. All these institutions are act of National Assembly. Their roles and responsibilities are very clear. For me, my fear is establishing this interagency compliance tax. That is, we are bringing institutions together to form this particular compliance. The answer to this is institutions should perform their role as it is mandated by this National Assembly. So establishing this interministerial compliance, whatever, is just some waste of time.
Honorable, please, let's get this clear, honorable members. These recommendations that we are talking about, that the minister is responding to, emanated from us. Am I right? We made those recommendations. Because the FPAC and all these things made their report and tabled it here, and we adopted it, we approved it. So we don't question that. It's them to question that if they have questions on it. But for us, we don't have time to question those ones. Who is going to answer for you?
Okay, thank you very much, Honorable.
I think you have more than enough. We give another chance to somebody else. Honorable Member for Kiang West.
Honorable Speaker, my question is with respect to government's response on page 6, recommendation 2, executive should administratively hold to account the head of the police, Gambia Port Authority, not necessarily Gambia Port Authority, I think that's an error, Gambia Revenue Authority, and the Central Bank of the Gambia for their inaction following receipt of intelligence report from the FIU. And the main interest of my question is paragraph 2 or 3 next to what I have just read in the page 6 says, or paragraph 4, the police commenced an investigation into the activities of Apogee FZC, Creed Energy, Ultimate Beige Logistics for potential violation of the AML/CFT Act of other financial crimes. This was halted only when after the source of funds was established. But the police testified that the investigation was never halted. Their prior testimony, prior to that, they said the investigation was halted. When they reappeared and they stressed that, confirmed that the case was KIV, keep in view, but it was never halted. But contrary to that, government responded that this case has been halted prior to after establishing the source of the fund. Can you reconcile these two testimonies from the police, which IGP represents, and the response of the government? And as well, my other question is, how do you establish the source of the fund?
Honorable, take it one by one. Your first question is for him to reconcile those two, isn't it?
Exactly.
Yes, let's hear him. I don't know whether he understood you well.
Yes. Thank you very much, Honorable Speaker and Honorable Member for Kiang West. What triggered the whole investigation was a STR, that is Suspicious Transaction Report from the FIU. And this is normally flagged when anomalous or unusual volumes or kinds of inflows are noticed in the system. And they are reported to the police for them to do further verification, with the sole objective of identifying the source and the nature or legality of the transaction. What the response is saying specifically, yes, the investigation started and commenced, but when the source of funds was verified, the investigation was halted. That means they are not proceeding further because the objective of the investigation to determine the source of funds was established. So it's no longer a suspicious transaction report. Thank you.
Honorable Speaker, IGP's testimony through Ta'aliu in the presence of IGP said they've never halted the case. They said the case was kept in view, KIV, and they kept that in record. That this was explicitly captured in our report. They said they've never halted the case. The case was kept in view, and the government responded that the case was halted after the source of fund was established. This is the reconciliation I was asking for.
Honorable Speaker, Honorable Member, this report was not an afterthought compilation. All the stakeholders were put in a room and contributions received from parties concerned. And the report we have here is a reflection of that consolidated response. So if you find any conflicting response from this and the testimony, I think you may need to do substantive rework on that. Thank you.
The Honorable Member for Lower Salum.
Honorable Speaker, thank you very much for giving me the floor. And Honorable Speaker, it's rather unfortunate. The transparency and accountability that we expect from them, they do not deliver it as we expect from them. Yes, if a state minister says that the parliamentary recommendations and resolutions are not binding, we expect such a report like this to come in our decks. Honorable Speaker, Honorable Minister, already the central government has acted. Are you telling us the fine that is on the banks is illegal? Because already they have acted and fined banks because they have found that the substitution transactions that are going on is illegal. And it's not in line with the banking system. This is why they were fined. You telling us now today what the central bank governors acted is unlawful. A response from you. Honorable Speaker.
Yeah, you ask question and let him answer.
Honorable Speaker and Honorable Member for Lower Salum. Suspicious transaction and banking regulations are not one-on-one mirror image of each other. You can have a lawful transaction going into the banking system, but the way the bank handled that transaction internally could be faulty, such as KYC, such as opening a sub-account when you should not have opened a sub-account. That does not mean that the original transaction was suspect or was fraudulent. When the central bank fine a bank, they fine the bank under their under their banking supervision regulations, which are different from legality or otherwise of the source of the transaction. For example, if a customer lawfully goes into the bank and lodge funds, but in handling that fund, the bank made a misstep, the funds are lawful, but the bank can still be fined for not doing its job according to the regulatory requirements. So the central bank finding the banks doesn't mean that the source of the transaction is illegal. Thank you.
Honorable Lower Salmi, you can come back again. One more time.
Honorable Speaker, on the other side of the report, I can't read the whole part, but then just one part of it, the matter on the investigation, that is allegation of
Just
bribery.
reference the paragraph. That will be easier to follow. Item, because there are
This is
paragraphs.
the government response of parliamentary inquiry. That's the first paragraph. Yes. Yes.
Go ahead.
That's it. The allegation of bribery, money laundering, and tax evasion by Apogee FZC, Grid Energy Limited, and Ultimate Beach Logistics. No, that's the first.
That's the letter.
Yes.
That's the letter.
Yes. That the sales of petroleum products, 36,000 metric tons, the value of $30 million is not be established. Honorable Speaker, if you check on the conclusions of the committee, it doesn't mean there was no tax evasion. You understand? Money laundering, corruption. You see, Honorable Speaker, the committee on this issue, basically, they are telling you this company are listed. they have not seen their connection on that. These companies, not the official people in the offices. Honorable Speaker, if you don't take charge on your office by the laws that are governing you, just because of, for a reason, Honorable Speaker, that is unlawful. One, yes, I'm coming. I'm just trying, because, you know, we have limited time. So this is why I'm just trying to lay the foundations. Because of the way the report is given us, we cannot give them what we expect from this report. You get me right? So this is why I'm just making my foundations whereby I can able to get some answers from him. Can I continue, right? Yes, this part doesn't mean there was no corruption and bribery. This is why now the committee now is asking them to establish an inquiry from the office of the IG. In fact, Honorable Speaker, the committee members have done a thorough job. Before releasing this report, they could have allowed the IGP to continue on the investigation, one. Two, the witnesses that came through us, because the committee have written document, they have voice record and compile the truth. But then they don't do it, so they just act the way they want to. This is why I said it's rather unfortunate, Honorable Speaker. We expect the government who should make a transactions of transparencies are giving us these false documents in our presence. I expect it not in this way. Thank you very much.
Thank you, Honorable Member for Lower Salum. Honorable Member for Nyamina Danku.
Can I respond? Yes. Can I have the report? Yes. Yes. Honorable Speaker, our response to say it was not established is not our own making. This is on page 92, first paragraph of the report of the Parliamentary Inquiry, and I will read. It says, conclusion paragraph of the National Assembly report. It says, the Joint Committee, having conducted an exhaustive inquiry pursuant to its mandate, finds that the matters under investigation, that is, allegations of bribery, money laundering and tax evasion by Apogee FZZ, Creed Energy Limited, and Ultimate Page Logistics on the sale of petroleum products worth 36,953,614 metric tons, valued at $30 million, could not be established. We did nothing but just reproduce what the report conclusion was. And it's on page 92 of the National Assembly report. So we are not doing it, we did not even transcribe it. This is on the report of the National Assembly inquiry, page 92. Well,
Okay, thank you.
This is the report of the
Honorable, okay, thank you, Honorable Minister. Honorable Member for Nyamina Danku.
Thank you, Honorable Speaker. Honorable Minister, on page...
graph reference, because the pagings are different. The paragraph.
on your
And quote the paragraph
page
number.
5, paragraph, the last paragraph, where you said, I will read the recommendation and give my answer. The police comment and investigation.
Have you quoted the paragraph?
Yes,
Big no-
it should be on page 6, the last paragraph. Yes,
You know, if you look at on top there, that's the response. Huh?
yes,
You know, just quote number 2 is the paragraph.
yes, on number 2.
Then you say the response, paragraph 3.
Okay, that's the...
Okay. Paragraph 3 of the response. Yes, go ahead.
The last paragraph,
Yes,
Honorable Speaker, is where I have a concern.
Yes, go
Because
ahead.
The response read, the police comments and investigation into the activity of Apogee FZP. The last paragraph. On page 6.
Honorable members, if you look at paragraph 2, that's where the recommendation is. Recommendation 2. On page, because I was made to understand we have different pages. But if you look at that, under 2, number 2 will be the same, 2. Under the response.
Under the response, yes.
Under the response, you have paragraph 1, 2, and 3. Response has
The last one.
the last paragraph of response, 1, 2, and 3. Have you seen that?
Okay, and it reads, the police comments an investigation into the activity of Apogee FZP, Green Energy and Ultimate Wage Logistics, for potential violation of AML/CFT Act and other financial crime. This was halted only after when the source of funds was established. Honorable Minister, my question is, how was the source of funds established before the investigation? Because it was taken there for investigation. But actually you are telling us it was halted because you already know the source of funding. How did you know, or how did you establish the source of funding? That's my first question.
Thank you very much. I have already answered a similar question. When a suspicious transaction is reported, the whole objective is one either is anomalous, is large, is not consistent with account history. Different reasons can be quoted. So what the investigation will go, it will trace the source of funds. Like, for example, in this particular case, the source of funds was traced to local purchases of the fuel product, which was paid locally in dollars instead of foreign currency. That is the whole gist of the matter. It was not money that was unrelated to oil that was packed into those accounts. The whole subject of this transaction was as follows. Previous to this, all traders used to request payment in foreign currency. There was foreign currency shortage. This particular trader offered to take payments in dollars. So when the FIU saw those large volumes which are inconsistent with the account history, they reported it as an STR, that is suspicious transaction report. And the investigation went on to verify, yes, indeed, the monies are from oil-related transactions. That's what we understood from the investigations. Thank you.
Honorable Member for Nyamina, Dankunku, go ahead.
It could be a follow-up question before my main. Honorable Minister, you already informed us trading in dollars. And the particular company that we're talking about here is Apogee. And we are categorizing them as international trader. When somebody is trading within your country now, where would you classify that trader? It is a local trader or an international trader?
So much. Okay. The classification of local or international is taxation-wise called domicile. Where are you legally registered to conduct that business? If you are an international trader, you are deemed to be trading offshore. But there is nothing to stop you from taking your proceeds in any currency of your choice. Being offshore does not mean that you cannot receive your payment in local currency. It's your choice. Like today, you can, once you are offshore, that means jurisdiction-wise, taxation-wise, you are not within domicile of the Gambia. You are outside the taxation system. That's what has been operating in the sector. Thank you.
Actually, my own issue is about the economic activity that is happening within the country, not whether he's taking dollars or not. But what was happening, it was the economic activity was done within the country. He was in a hotel here. People are releasing invoices, going in the hotel, paying him. That's the economic activity. That's what I'm trying to, contextualize then for me, I don't regard Apoji at that material time as an international trader. But he is doing what is our OMC, our own oil marketing company, he was doing. That's what he was doing within the country.
Unfortunately, that's not captured in the report. I've not seen that
Okay.
in the report. Thank you.
All right, I now invite the honorable member for...
Honorable,
Yes.
I don't finish my question.
Pardon?
I don't finish my question. I have.
I can give you one more. We are time constrained.
Okay, Honorable.
Okay,
Honorable
go
Minister,
ahead.
My other question is on the issue of the policy. Honorable Minister, do you normally approve government policies, ministries at cabinet level? Do you normally approve policies of cabinet?
Well, you know, as a minister, your function is policy. You don't focus on operations. So it is up to the minister to elevate policy to cabinet if he believes the policy is cross-cutting that his other colleague cabinets will need to know, or if it is within a certain jurisdiction that is under his purview, it is his jurisdiction or discretion to decide that this policy will be within a close confine and as such might not require cabinet approval. It doesn't mean that failure to take a policy to cabinet is any breach of cabinet procedures. That's what I understand. Thank you.
Thank you. Honorable member for Brikama North and Minority Leader.
Thank you very much, Honorable Speaker. Let me thank the Honorable Minister for responding to the report of the committee as called for by our standing orders. The report has highlighted the position of the government in the respective recommendations and the resolutions, with not an instance where the government accepted the recommendations. Now concerned on where resolutions or recommendations are accepted, the timeline of the implementation. It is one thing to accept, but another to implement. We are struggling with our previous resolution, and I must say that we are not happy with the way and manner they are implemented. And if this one is also coming, it's important we bring that to your attention. If you look at it, most part of it, Honorable Speaker, timeline is given 90 days after the adoption. Now where you stated that the government will be implementing, when do you measure to commence the implementation? Or have you already started implementing? And when do you intend to, if not? And then where we may differ in terms of opinion as a committee, the committee will review our recommendations. What your response has not changed our position. We'll do our thorough consultation with our legal team. Having met with your experts or different entities to make this report, that's your side. But that cannot put aside the position of our committee and the National Assembly, because this is also based on informed testimonies that were provided by the relevant witnesses. I want to question, if I've made that clear, let me question where you stated page 11, paragraph 14, on the issue of Mr. Jallo pending the review by the Minister for Justice be sent to administrative leave. You noted that the Minister of Justice noted this recommendation. These are regarding the administrative leave of Mr. Jallo fall within the purview of the employing authority. That means you are not taking that responsibility. Accordingly, upon completion of our review and filing of any necessary process, we will advise his employee as appropriate. And then sending Mr. Yorojalo and Mr. Leave pending the review outcome for alleged perjury would not be necessary at this juncture. If you are not taking the responsibility of the authority, I think it will, I will not necessarily put it that way, but I will reserve to say it will be premature for you to take a position on something that should be taken by a different authority. That will be my expectation. For your review, yes, you can do with that, but if you are saying that this is meant for the different authority, allow that authority to make his mind on that. That is my observation. And then accordingly, as you are making referrals to the appropriate institutions, I would also advise that you refer that matter to the authority that you mentioned for them to act on our recommendation. And where you make the matter to be directed to so and so, who should do the direction? Is it the National Assembly or the government? If it's us, tell us, then we will direct. But if you are going to do so, fine, clear us so that we know what to do. Thank you.
Honorable, before you sit down, Mr. Yoro Jallo, where does he work?
Thank you very much. And I think, Honorable Speaker, Honorable Minority Leader, the Speaker's question is very pertinent. GAM Petroleum is not a government-owned company directly. It's a private limited liability company. This is not under direct purview of the government. Even though majority shareholding is by entities that are government-owned through parastatals. It's not 100%. I can give you the breakdown of the shareholding. We have 75% parastatal shareholding. These are Ministry of Finance, Social Security, GPA, and GAM Petroleum. However, there's a private sector shareholding of 25%. As such, corporate governance dictate that once you are not a direct ownership of government, government cannot impose directives on you. Rather, we can refer the desired course of action to the governing body of that institution, which is the board of governors, or board of directors, which is what this directive is seeking to do. The board of directors of GAM Petroleum, being a limited liability company, will make their own determination whether the recommendation of the National Assembly is consistent with their own internal bylaws and procedures. And that's exactly what we mean. Thank you.
Are you insinuating that you will be directing the recommendation to the Board of Directors of GAM Petroleum? That's one side. But I also want to say that where you made a conclusion, since you don't want to take that responsibility, is the GAM Petroleum, you should reserve your opinion on the issue of administrative leave. Allow that decision to be taken by the competent authority.
Understood was that you expected immediate action, and given that it's referred to a body outside government, we cannot act on it immediately.
But here you decline in that immediate action.
I don't know how more clearly can I put that. Look, if GAM Petroleum was a direct ownership of government, government should not have taken this course of action, because government has the governance mandate to impose its action on the company. But because GAM Petroleum is a limited liability company, it is governed by its own bylaws and memoranda of association and articles of association. So you cannot, as government, just go and impose a course of action without going through the governing body. That's our explanation on this point. Thank you.
Speaker, Honorable Minister, that is very clear. I understand. That means you are directing the resolution to the governing body. What I'm concerned is for you to make this conclusion Sending Mr. Jallo administratively pending the review outcome for alleged prejudice would not be necessary. You are not taking the action. Reserve yourself on that.
Point noted.
Very well.
Yeah.
Honorable, thank you, Honorable Member for Bikama North. Honorable Member for Sani Mentoring.
Thank you very much, Honorable Speaker, and thank you very much, Honorable Minister, for taking action with regards to the committee's recommendation. Honorable Speaker, the Honorable Minister, in all your responses that you've given to the plenary with regards to the actions or the further actions that the line ministries will do the further investigation with regards to other cases or other investigations that other line ministries will conduct. So far, you haven't given any time frame. I am really concerned because when the committee is given the report, in the report, the committee have recommended some time frame, like 90 days or below 90 days for some investigation that report back to the plenary, which you've just done. So, but in your responses, we've not seen any time frame that you've included with regards to the further investigations that other line ministries will do with regards to certain investigations. This is what I want to do. Thank you.
Thank you very much. I think the issue of time frame has been addressed because it's deemed from the date of submission of this report to the National Assembly. And if you recall, even the report that the executive received, the timeline that we were given, we observed that. And the clock starts counting from today, when the report is laid before the National Assembly for the 60 days and the 90 days referred to. Thank you.
Honorable Member for Fonyi Kansala.
Yes, thank you, Honorable Minister. I want clarity in these two things, and I want you to assist in maybe clarifying the two elements. That is Resolution 30, page 18, the response. Are we there? 30, yes, page 18. Response. It says the government holds the view that the former Minister of Petroleum, Mr. Abdullah Job, acted within his ministerial powers to issue the policy, whatever number given 02, as referenced in the letter dated 30th October 2023. Now, when you go to page 25, Resolution 55, it says response. The Minister of Petroleum will work with with PURA GCCPC to develop a ullage allocation guidelines. Meanwhile, the Ministry will compel the depot to allocate ullage on the equitable and the first come, first served basis. I want to understand these two elements. Part of the Minister, when he met the committee, he was saying it is also part of his people to develop that policy in order to address this ullage issue. But you're also saying again that the two ministries, including your ministry, will work on this. I want you to help us here. You said the minister has the powers to do. You're also shifting that ullage issue onto your ministry, including PURA and also GCCP.
Minister of Energy.
Minister of Energy, yes.
And Minister of Energy, not Minister of Finance.
Okay, Minister of Energy,
yes.
PURA and GC. So, yes. What must have been the gap that you find it necessary to include these three instead of holding on to what the minister has done?
Yeah, thank you very much, Honorable. What the minister has done is a policy which we deem to be within his authority, and still is the same ministry. Part of the review will be the adequacy of the existing policy. If it is adequate, they may keep it as it is. If it is not, they can improve on it. Thank you.
Yes, a follow-up, Speaker. Yes, in that view, are you saying that there are such, that's why two are included in the ministry instead of adhering to the ministry policy alone?
What we understand, the policy was not very well understood. As such, it's a subject of an inquiry. So the multi-stakeholder, that is the ministry still, with PURA and the Competition Commission, will review the adequacy of the policy If deemed adequate, it may stay as is. If not, they will enhance on it. Thank you.
Thank you very much, honorable members. Honorable members, honorable minister, thank you very much for ably responding to honorable members' questions and concerns. And honorable members, we thank you for your insightful questions to get answers to some of your doubts. Honorable Minister, thank you very much. Honorable members, the next honorable members, if you look at the other paper, we have to rely on section 14.3 of our standing orders, very little, because it only talks about bills, and they are all bills. But because of our own internal procedures, we preference usually bringing them this order, but we will have to alter the order because of certain emergencies we have. So instead of having orders 67, the second reading of the prerogative of mercy bill, we will move to the continuation of the consideration stage of the National Assembly Security Bill 2024. Security Council Bill, rather. So, clerk, do we proceed, please?
Thank you. Order 72, consideration stage. Continuation of the consideration stage on the National Security Council Bill 2024 by the Honorable Attorney General and Minister for Justice, stepping in for His Excellency the Vice President.
Thank you very much. Honorable members, you will recall that after the second reading stage, the bill automatically stood referred to the ABC. Thereafter, the ABC scheduled the bill for consideration stage during the previous ordinary session in March, precisely on Tuesday, 25th March 2025. However, the Assembly could not complete the consideration stage of the National Security Council Bill 2024 and stopped at clause 18 of the bill during the said sitting, and hence suspended the process. Therefore, the bill is appointed today for a continuation on the consideration stage in accordance with Order 72. During the consideration stage, members shall have the opportunity to give detailed consideration and scrutiny to every clause and schedule in the bill. This stage also provides the first opportunity for amendments to the bill to be debated and voted on. I will now therefore resolve the committee into the committee of the whole, the Assembly into the committee of the whole Assembly to give consideration to the bill, that's the National Security Council Bill 2024. The Assembly now resolves into the committee of the whole Assembly. Honorable members, the Assembly will now go to into the Committee of the Whole Assembly to consider the National Security Council Bill 2024 clause by clause. We will be guided by Order 72 of the Standing Orders during the consideration stage. As I said earlier, we're going to clause 19 now, and then the clerk will lead us through.
Thank you. Clause 19, funds of the office.
Chair.
Who is talking? Where are you based? Why are you so far?
Yeah, Chair. Yes, we have 17, Chair, on 19, clause 19, sub 5. That is a minor amendment. 19, sub 5. You know, you have on the third line presented to a special committee of the Assembly, Standing Committee on Defense and Security. Sub 5, the audited accounts of the office and the Auditor General's report on those accounts shall form part of the Auditor General's overall annual report to be presented to a special committee of the National Assembly, to be presented to the Standing Committee on Defense and Security. The relevant committee. Presented to the National Assembly.
Honorable, just hold on. In fact, we should go a little bit behind. What the table office did was to renumber. You know, there were renumberings to be done.
Renumbering should be 20.
Those renumberings should not affect what we have not dealt with yet.
Yes, because the numbering, when you look at the numbering, it should be 20, then 20 should be 21.
No, that's why we go to the original numbering.
Exactly.
And we are going to start with 18. That's where you have part 5, financial provisions, on page 15. Have you seen that?
Yeah, that 18 should be 19.
Now, unless we amend it, we have not dealt with it, so we cannot be amended. We are going to read it as it is, and then it will be amended.
Then when we finish, we amend it.
Yes.
All right.
All right. So he has read funds of the office. You have read that clause. Can you read it again? Can you read it again?
Clause 18, funds of the office.
It is proposed that clause 18, funds of the office, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. Now you go to the next one. That's where you have now. Go ahead.
Yes, that was.
Yeah, go ahead.
Clause 19, estimates, accounts, and audit.
Yes, Honorable.
Yes, as I said on clause 5, what the committee recommended was to change the special committee to the National Assembly Standing Committee on Defense and Security, but members are sent to the National Assembly only. Or to the National Assembly only.
To the National Assembly.
To the National, let's just to the National Assembly. To relevant committee of the National Assembly. The same, to the relevant committee of the National Assembly. No problem.
You are saying two different things. Referring to the special committee of the National Assembly and to the National Assembly, which one is which? You know, all bills should be referred to the National Assembly. All bills, whichever committee you are doing it on behalf of the National Assembly.
Exactly. National Assembly.
So,
to present it to the National Assembly.
Presented to the National Assembly.
Yes.
To a special committee of out. Yeah? Okay. It is proposed that clause 19, estimates, accounts, and audits stand part of the bill as amended. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 20, annual report.
When he reads and I hear nothing from you, I'll proceed. Immediately he finishes, if you have any observations, anybody.
Yeah, we have no observations. What we have on our report, it has been addressed by you. That is the numbering.
Yes, yes.
Yes.
It will be renumbered.
Yes.
All these things will be renumbered properly. It is proposed that clause 20, annual report, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 21, National Security Sector Joint Operations Fund.
It is proposed that clause 21. You have something?
Chair?
Yes?
Yes, we have few amendments to that, and that is clause 21. That clause 21 sub 3. Yes, from sub 3 to E be deleted and replaced with the following. 21 sub 3. A, B, C, D, up to E.
Up to E.
Yes, sir, to be replaced with the following. Yes, Honorable Chair. Chair, your mic. We can't hear you.
The whole of 3, A to 3E should be removed, and then you have a proposed replacement.
Yes.
Okay? Can we get that proposed replacement?
Now,
is it one replacement, one paragraph, or the same as those ones?
yes, we are replacing A to E. It's in the report, sir. Page 13.
Oh. We have not with the report now. Just hold on.
Can I read?
Just hold on. The recommendation on the report is A, B, C, just like up to C. No, there is no D.
It's up A.
No. What I have here is only C.
A, B, C.
C has sub, and that's where it stopped. Sub. No. Honorable Deputy.
Yes, Honorable Chair.
If you look at your report.
My report, yes.
And then you look at your proposed recommendation.
Yes. Maybe.
And you look at 1A, B, you look at C. Have you seen C?
Yes.
C1, 2.
Maybe you allow us to read so that.
No, I'm not after that. C1, Roman 1, 2, and 3. Have you seen that?
Yes.
It continues on the next page. Roman 4, 5, 6, 7, 8, 9, and 10, and 11, isn't it?
Yes.
Then then you go to the next one, there is 2. What 2?
21.5 is recommended.
That is sub 5.
No, you go to, where you have that clause 21.5. You know it's number 2, Roman 2. That is going to be confusing.
Yes.
The numbering is wrong.
Yes.
So you have to correct that first before we go into the details.
That one is the report.
Pardon?
Yes, it's the report.
Okay.
Changing the number. We have recommended that the numbering
is in the report. All what is in the bill be removed to be replaced by your proposal. Your proposal should be numbered according to the bill.
Yes.
Chair.
Your Honorable.
Yes, yes, yes.
Yes, I think the Roman figure we are talking about, the first one is under the C category. C. So they are not mixed. So the Roman figure from 1 to 21.
No,
It's
she
under
cannot
C.
have, no, she cannot have two. C is, you have one first on page 3, on the first page.
Yes.
You have 1, 2, 3 Roman.
Yes.
It continues up to 11. It continues up to 11. Then look at it. The next one there is 2, I have. What? Then that can, Honorable, that can, you cannot have that sequence. You have C, Twenty-one three.
Can you allow us to read what we have?
The committee recommends
For
that
an argument.
clause 21 stand part of the bill with the following amendment. Now, Roman figure 1. This Roman figure 1.
Chair, if you are making amendments to the bill by the various numbers amendment, you are asking us to remove all what is on 3. That's what you said. We are removing everything. So if we are to bring in something, it must be numbered according to the bill.
Because we can work on
Not
that.
according to the bill, who is going to do that?
We can work on that.
Yeah, this is what I'm saying, this is what I'm saying. Now you work on it, that too should not be there.
We will remember as they read.
No, you don't understand me. It's not the numbering read. You see, you have A, you have B, A, you have B, you have C. C is divided into Roman 1, 2, 3, 4, 5, up to 11. Now from the C11, C Roman 11. Then you now have again 2, Roman 2. How are you going to have Roman 2?
It's wrong. It's wrong.
Yes,
Yes.
it's wrong.
It's wrong. So, Chairman,
It continues from 11 to 12.
now, Chairman, Chair.
Yes.
Now, let's follow the sequence now.
Honorable
Let's follow the
Chair.
sequence now. Let's say 21, 1, 2.
21-5.
What they have now,
Chair.
let numbering continue
Chair.
now. 3, 4, 5, 6,
Chair.
up to the last one.
Chair.
So we can go away with
What
one
listening to-
or Roman 1 or Roman 2.
Chair.
Listening to
That's fine.
Chair. Chair. Chair, you have.
Listen to the committee to explain.
Chair.
21-5.
Chair.
It's not the same.
Chair.
Deputy Speaker,
Yes, Chair. Honorable Speaker, sir.
just hold on. Yes, go ahead.
Honorable Speaker, you know that number in Roman figure 2, it's clause 21.5. That one it should be under 21.5, not 3.
21-5.
5. Then the 3 Roman figure you are seeing
21,
there,
wait.
is there? It's on in the. I'm
No,
not sure whether
21-5 of what?
21.
Of the bill?
Yes.
21-5 of the bill.
No, yeah, it's close to 20. Yeah, exactly.
Honorable, what you have done is wrong. Honorable, you see what he was trying to explain? He's trying to explain that this is not part of it, which is true. But then if what you did at the first one, if what you did here on page, what you did here, that number, if you look at the beginning, you said that clause 21.3. Have you seen that? The beginning of your recommendations.
Yes.
That clause 21.3a to E be deleted and replaced with the following. That one you number, that number should be, for instance, number 1, complete 1. Number 1, if you say number 1. Then, if you want, you go to the sub-clauses, because you are saying a 5%, if you look at the bill itself, where is the bill? The sources of the fund. The sources of the fund should be there. Then this one should be 3. If you have that one, then where you have 5%, 5% should be 3A. 3A. Let me
Speaker,
just end this with you.
Speaker.
Are you following me, Alayi?
Yes.
It should be 3A.
Speaker.
Yes, let's have the AG.
Yes, Honorable Speaker, I think it's simple. If you look at the recommendation of the committee, it said the committee, if you are with me, it says committee recommends that clause 21 stand part of the bill with the following amendments. They made three amendments in this clause. Those 3 amendments are the one they numbered as Roman 1, Roman 2, and Roman 3. But under each Roman...
No, where is that?
That's what you... immediately under it, you see Roman 1. And they are Roman 1, that's their first amendment.
Where is Roman 1?
That first small Roman 1 you are seeing.
And read it.
And that's the clause 21(3), A to E. So in this one, they are now amending only A to E of 3, clause sub 3. Then they will have to deal with that. When we finish, then you go to the second, up to the other side. Then their second amendment in this clause, that's what they number Roman 2. And their third amendment, they number it Roman 3. So they're saying we are suggesting 3 amendments in this clause. And they number those 3 amendments, Roman 1, Roman 2, Roman 3.
No, AG, you can't have... AG.
No, I'm not,
what we are saying is, these proposed recommendations must be taken into the bill. How are you going to number it on the bill? You're not going to number it this way. No. Your proposals should be numbered according to the bill.
Speaker.
So that we will take it up there and put it in the bill and it fits in there.
Speaker.
You cannot bring in any other, your own this thing against this thing.
Chairman.
Yes, Village.
You see, the mistake, the committee really...
No, it's not a mistake.
Please, wait. My friend, keep your comment to yourself.
No.
The mistake of the committee. Please, allow me to run committee. No. If you are not allow the committee to please, you make your comment. But you are not allowing the committee to make it.
Please, let's respect each other.
Please.
Whether you have made a mistake or not, his opinion is a mistake. When you said make him know that it is not a mistake. But no. He has an opinion that he can say. And then you go and correct him if you think you are right.
Thank you.
You cannot tell him, he cannot say it. Whether he is right or wrong, he has an opinion. Listen to him. Yes, please.
Thank you. Chair, if you look at clause 21, National Security Joint Operation 4, it has sub-clauses. 1, on the bill, and 2, 3. They are asking us to delete the 3. If they are bringing any proposed amendment, it shouldn't be in Roman figure 1 again. It's supposed to have 3. No, please, don't say no. It's supposed to be 3. We start 1, 2, and 3, because they're removing 3 there. You must replace 3 again.
No, the committee,
I'm coming.
The committee,
I'm coming. You delete 3, you must replace 3 in the bill for the sequence numbering to move. Now you can bring your Roman figure on the 3, but you can't have your subclause 3, subclause 1 Roman figure, and you have subclause again Roman figure. It's wrong.
The committee, I think you are in agreement that clause 21.
Can you hear me?
Yeah, no, listen first. Clause 21, 1, you are in agreement with that. Clause 21, 1 of the act, of the bill. Pardon? I'm not what? We are not hearing, I'm not hearing you. You don't need to explain. What do you need to do to clarify our doubts? You have explained on the record, we don't understand. We tell you what we don't understand, and you clarify that.
Chair.
The committee, come up.
Chair, you know what our arguments are, that the process or the procedures are that once it is read by the clerk, you allow the committee to lead and read their amendments then you open up for debate or for questions. But if you start that without hearing from the committee, we'll just listen to you people.
Yes, but you know, what you told us was everything of 3 should be out.
And then,
No, that's what you said. Am I right? And it should be replaced by everything of your proposed 3, your proposed amendment. Am I right? Now, what I expected for us to do that easily was not just to read it, because we all have copies of it. We would have just read it and then moved it directly inside to fit in there. That's what I was expecting. So when I looked at it, I saw it numbered differently. That's what brought about this. Or you are talking about, you are going to bring about a different numbering from this?
No, Chair.
All right, go ahead.
When you saw the numbering, you should have just asked us, allow us to respond.
But I asked you.
No. All right, now, Chair.
All right, go ahead now, lead us.
All right, because because the numbering of the report is not going to the bill. Attorney General, are you following? Now we said, Chair.
Honorable, please lead us through what you want.
All right, clause 21, clause 21, sub 3. Let's go to sub 3. You see, sub 3, source of funding. Then we said sub 3A. That is why on our recommendation, we say Roman figure 1, that is A, sub 3. Roman figure 1 here is representing sub 3. That is A, B, C, and all that what we have. We will just pick it and put it on Roman 3A. Roman 3A, we want it to read as follows. A 5% of the revenue generated annually from the international gateway, notwithstanding, the minister responsible for finance may vary the percentage depending on the circumstances prevailing at a particular point in time. That is A. Then B, we said a 5% of the revenue generated annually from the insurance premium, notwithstanding, the minister responsible for finance may vary the percentage depending on the circumstances prevailing at particular point in time. Then 3B, C, we said order B, C, 3C, order such reasonable amounts of monies obtained from the following. That is 1, Roman 1, national security levy processing fees on the sale of passport forms. 2, national ID card forms. Then 3, alien forms. Alien. Then 4, resident permit A and also community forms. Then 5, resident permit B and community form. 6, entry clearance forms. 7, emergency travel certificate forms. 8, entry visa forms. 9, extension of stay forms. 10, naturalization form for community national forms. 11, driving licenses and learners form. Then this Roman figure 2 that you are giving, it's amending subclause 5. 5.
In the bill.
It's recommended to be amended by substituting it for the following. That is 4. Yeah, that's I'm just letting you. So we can stop at 3. When we finish, then we go to 4. Now on this one, now
the whole thing. Because you people, what you did actually is, the already existing provisions, you amended them, simple, one of them. That is A, you amended, added something to it. B, you added something to it. C, you deleted it. You have seen that? So yes, that's what we know, then we will remember them. This is what we will do. But if you give us this way, we are going to put this thing here, we have to number them. So what we are saying is, this thing is, by your proposal, it should be, the first one should be 3A. 3A, it should be the first one. The other one is 3B. The next one is 3C. And then that's where it stopped. That's where it stopped. For that particular 23 subsection 3. Then we insert that and you go to the next one. So, are you, Honorable Chair, Are you in this thing with us?
Yes, sir.
21.3 is A. Your first one A is our A. Your B is B.
Yes.
And then we will see the C as C. That replaces the whole thing here, because what you did was
Yes.
for the main bill you removed the whole thing.
Yes, yes.
Huh? Then we are complete with that.
Yes.
Honorable members,
Sorry.
Honorable members, you have heard that. We are in agreement, isn't it? Yes.
Why did they remove the C, the 0.25% of national security levy on import duties? Why do you delete it?
Let me look at it. Let me look at the
On
finance.
C,
Let me look at the finance.
C, Chair, this is in consultation of Minister of Finance. Chair of committee.
And then yes, that one. Yes, you know, we had consulted, of course, the Ministry of Finance and all, and they sent in their position papers on all those things. In fact, the reason why we could not.
Finance is here.
Yeah, it's okay. They have
This is a
with
report
letters.
from
No.
Okay. Justification has to advance. Yes. Justify. You know, there are many other laws with certain institutions who derive their funding from these revenue lines. So if you want to take all, you are affecting other institutions' a share of the same revenue line. So finance has to guide you how many percentage you get from each of these revenue lines.
And then
Chairman, are you okay with that?
01, no, we are not including it. We are deleting it.
Okay, let's go.
Yes.
Chair.
Upper Salum.
Yes, if you remember, when we dealt with those bills from Mohas, and the issue we committee had was we don't want to create an institution and then staff the institution. If we're going to say that we're going to take 5% revenue of the international gateway, the gateway funds are already distributed. Some are going to the private sector, and some are going to the government side. So this 5% talking about, where exactly is it going to come from? Is it going to come from the private sector, or is it going to come from the side of the government?
No, that one is coming from, they have government side and look at all the percentage. It's coming from government percentage. And then that is why you look at sometimes based on the volumes of all this percentage, the minister may vary. If the volumes are beyond the budget, then the minister will only...
But if you look at the revenue estimates of 2025, no, I'm just telling you, the revenue estimate is showing zero.
If it is zero, then that means...
Will decide.
Yes.
No, exactly, and that's exactly what I'm saying. You don't want to create an institution and then staff it. So for me, what I think is best to do is let's look at something that is solid, something that is predictable, not something that you cannot predict.
No, this is...
Wait, let me come, Honorable. We are creating an institution, and we are saying that we want to create a fund for the joint operations. So the money that must go into that particular fund is must be something that is really very sure.
Yeah, if you look at all these monies, the forms, the passports, and all the appropriations, there are a lot of monies that are guaranteed. It's not only one. So what you're talking about, in the event that that is not possible, then the minister may vary.
Honestly, Speaker, my stand is this.
Honorable Speaker.
If we...
Chairman.
No, Harold, let's give them money. Let's give them the money. Don't give them these percentages. Give them the money to them to operate.
Chairman. Yeah, I think we can proceed now. They have cleared themselves.
A small correction. On C Roman X, that is 10.
AG?
Yes, I'm familiar with naturalization forms, but I don't know what they call naturalization form for community national forms. That kind of form, what kind of form is that? I think we just say naturalization forms.
Yes, we have. I'm not sure. The community, maybe they are referring from ECOWAS National, ECOWAS community.
Yeah, but
I'm not sure, but this is what we got from the Ministry of Finance and
yeah.
What we have on the bill is naturalization form. Sorry, naturalization for community national form. But you people, you have naturalization form for community national forms. Which is which?
I think this one, we call it directly from the position paper of government finance. Maybe is the,
No,
they are referring to ECOWAS nationals. You know, usually.
No, Honorable, I'm talking differently. What you quoted from the bill, is not, there is no form after naturalization. Look at, make the comparison. That one is naturalization for community nationals form. But on your proposal, you have naturalization form for community nationals form. This is what you have.
Choose our
Which one is which?
recommendation.
We are taking the recommendation.
Now, that's why, Honorable, now confirm to us which one you have. You remove the first form, just like the act itself, the bill itself.
Okay,
Yeah.
Are you following?
So we remove one form.
No, we just use the naturalization form.
This is what I'm saying. Your proposal, we remove the first form out.
Exactly.
Yes.
Yes, that's what we are saying. Yes. You will not finish your...
Yes, the question I had on this joint operation fund. No, you know, the majority they record me, you know, he's used to doing that, but yeah. No, what I'm trying to say here is this, Speaker. We are creating a very important institution, and we must be very certain the kind of money that they will need to be able to operate properly. Because we are saying that this forms this percentage, this percentage. Now, can they tell us exactly, for example, in 2024, with all these things they've listed, how much money was that? How much money was actually received in 2023? So if we do not know how much money we receive in 2023 for this, all that they've listed, and we do not know how much they receive in 2024, it'll be very dangerous for us to do that. And that's the reason why I'm saying we must be very certain to ensure that we don't staff the institution.
There is no appropriation by the National Assembly to this fund. There is none. There is none. It's going to be dependent only on these proposed ones.
My thing is we must put the National Assembly appropriation so that in case these other lines do not materialize, then we have where to go. It's very dangerous to do that.
Okay. No problem.
Where is it?
Yes, agreed.
Honorable Opasalu, why is it that if you look at 18 earlier on, that the funds of the office, it says money is appropriated to it by the National Assembly.
You have seen it?
No, but you see here, if it is not here, it cannot be appropriated, because the appropriation that these ones listed here are the ones appropriated by the National Assembly. That's where the funds are coming from. So if you don't put that one there, it means you cannot appropriate funds to the budget.
Yes. Then, Chair.
Yes.
Then if that's the case, then why do we need to create another fund? I said, if that is the case, why do we need to create another fund called Joint Operation Fund? Why can't we just put it one? I said, what I'm saying is, you know, on the 18th, like you said, we've already created the funds of the office. Okay? But then we went and created another fund called Joint Operations Fund. Exactly. Yes. So we must give money to the Operations Fund as well. So we are duplicating them.
From the funding of the agency itself.
To finance the joint operations that they have.
It's under the office. Oh, it's a separate office?
The rationale for them to separate the two, maybe there's a reason.
Oh, Chairman.
We are getting different advice that this is the most reliable source of funding for this particular office. That is the 0.25% of national security levy on import duties. That this is the most reliable
funding?
Well, it's for Parliament to decide, but the joint meeting we had the Ministry of Finance and them, and in their position paper, this is what they gave. They proposed that we delete 0.25% on import duties. But ultimately, the committee will only propose to the Committee of the Whole Assembly, and the decision is the Committee of the Whole Assembly.
Yes, I think this must be informed by a lot of reasons. What the Honorable Member for Upper Salim also said. You know, this levy is so much, every other institution gets a portion of it for its operations. How much do they generate? We don't know. It fluctuates. If you make all the institutions depend on it, it means you are also preparing the ground for their failure. Because there may not be enough money to fund them. That's why I think we should limit it. My point is, why do we have two funding accounts in one office? Honorable?
No, you know, the joint operations and probably the management of the office, that is the funds of the office. You know, the funds for the office, of course, money is appropriated by the National Assembly. But also, you know, the NSA will be the NAF center, will coordinate all the national security apparatus. When you look at the bill, when it comes into force, you have regional offices throughout the country. So, and then they are being centrally coordinated by a joint operation center. And the joint operation center may not necessarily able to rely on funds appropriated by the National Assembly, but that's why they have other source of funding, and that's where you have these levies. So the finance, they have calculated, they went through, look at also the budgets, of course, pressure on the budget, what they may expect and not, so they arrive at this, and of course they communicated that to Parliament through a write-up. That's why they were proposing the removal of that, and there are some other issues. So, but as I said, is the Assembly's whole committee's decision. If you believe that you can propose that, then that is fine. We can vote and move on.
Two funding offices in one district, because this is on their act. The bill is entitled National Security Council Bill. You know, and that office is the National Security Council office. So now you are talking about this one under the same office.
Yes, you know, when you
look at if it is a different thing or a joint one outside this one, then you should have a different act for it.
No, you know, when you look at the bill, you will have the Joint Operation Coordination Committee, you will have the National Security Joint Operation Center, you have then the Joint Operation Funds.
Under them?
Yeah, under
the council.
Under the council.
Yeah, and the council is the office. So that one, all funds there should go under that one. The funds.
What we are saying, Honorable Speaker, the Joint Operation Funds will finance the joint operation activities of the office of the NSA. And of course, it includes, as I said, throughout the length and breadth of the country. You know, there have been this, initially, we used to have formerly the Joint Operation Center, of course, the Army, the police, and everybody. So the Joint Operation Center will be financed, and their operation activities will be financed from monies from these levies. Now,
who manages them?
Office of the National Security Advisor.
This is what I'm saying. It's the same office that manages them. Anyway.
Yes. So are you proposing?
Can I, Honorable Speaker,
are you proposing?
Can I say something very quickly?
Honorable Chair, are you proposing we 21 we add it to under 50 under 18?
Yes, Chair.
Honorable members.
Yes.
Honorable members.
I want to.
Just give me a chance.
Okay.
Let's just hear an advice from him, and then you make your opinions.
Honorable Speaker, if you look at the whole bill, there are two funds. You have the national security, before even the security sector fund, which we are looking at, you have the funds of the office. But the funds of the office are mainly for administration of the office. That will be their salaries, allowances, office upkeep, and other things. The National Security Joint Operation Funds we're talking about, these are the funds that will be used for carrying out security operations. But if you go to clause, answering your question, if you go to 5, the Accountant General shall manage the fund. This is a fund that will only be paid out towards security operations. And the key function of this office is coordination of different security interventions. Currently, this is a big problem. Page 18, sub 5. I'm not too sure whether the committee is proposing any changes there.
Page 18, top 5.
Chair, AG.
Oh, your committee is proposing that the office manages it, yes.
Exactly.
Okay, I've seen that, yes, because it's an operational fund. We are now creating a special operational fund for security operations managed by the office.
Exactly.
That have to have a steady inflow of resources.
Sure. Yeah, just to, add it to where the AG stops. Now, if you look at all these things, you see there's a reason why they put the 0.25% levy from the security import duty. Because it's a short...
No, that one.
I'm coming. It's a short inflow of fund. Now, we can try a compromise. Maybe 0.25 might be high. We can really go down again to 0.15% and see if that could really help them. Because we cannot pass legislation here and also handicap them. So, I'm coming, Speaker. Let us propose, instead of deleting that, let's propose 0.15% of the security import levy to go into that.
Why? Chair.
Because the people who put it there, the people who put it there were the people who are now telling you, remove it. No.
Honorable Speaker, to correct that, this was approved in cabinet.
Exactly.
So I do not want to comment on Ministry of Finance unilaterally convincing the committee to change it. But this bill went to cabinet, it was discussed in cabinet, and this was approved, chaired by the president. So I do not understand how, during consultation, a ministry comes and override a cabinet position.
But, Honorable, that is usually very common. Almost all these bills go to cabinet. And when they come here during consultation, we go and alter, and they alter. They don't go back to cabinet. What I'm saying, this had been an issue over the period. This issue of this levy that Honorable Ngo is talking about has been an issue even with us and finance on one bill before. Yeah, that's the gateway I'm talking about. You know,
we're talking about the gateway, we're talking about the security import levy.
You are talking about this, if I'm right, am I right?
C, 0.25%.
Where is it?
National security levy on import duties. You know the import duties, that's why you pay also the ECOWAS 0.5 for ECOWAS contribution. No, that's why we are saying that let's go down.
All right, what are you saying?
This is not the first time the Minister of Finance, from the Minister or the Permanent Secretary, they frown us to put a percentage on the import levy. This is not the first time. So if the minister talks to them that remove it, I agree, because we have done that from the NACA, from the bills from the MOHA, series of them, student revolving, series of them. So that one is fine. But for me, what I'm trying to see is this. If it is about a fund for operation, for example, these are things you indicate on a budget line item, for example, like the security sector reform. It may be a continuous process. Or you have a joint operation, for example, the military, the police, the immigration, whatever. Those things, you put them on the budget line items. You put money on the line and then they are all segregated. So I don't think that's necessary to have created two different funds, because one fund must be enough and then we put everything there. And on your budget line items, you indicated on the budget line what you want to do with particular fund. You know.
Can I please come? Yes.
No.
You see, the legal basis for them to put that thing in the budget is from here. It's when you enact these laws that they can put that. That's why I said, probably yes, the 0.25% might be high. But like they said, they have been proposing things that in the circumstance the minister cannot fulfill, he can vary it. So we can also put the 0.15% in the circumstance they cannot fulfill, based on the situation, we can also vary it.
Exactly. Now, Honorable Chair, You know, on the matter of this joint operation center that the honorable member for Lower Salem is arguing, you see, once you enact this, as the majority leader said, into law, you are putting the mechanism here in which where they will derive or receive funds from. And this joint operation center, I just want to help you. It's not like the way now they are doing this joint operation now. No, this one now is going to be more formalized and operational 24/7 with various offices from the national to the regional level.
What are you suggesting now? Not you. What is you suggesting?
What we are suggesting now, we leave this thing at that.
What?
Now,
no, you have not said anything. We leave what at what? you say what we want so that we understand.
no, what I said, our amendment on 3, A, B, and C.
Honorable.
Our amendment on C, that's the 0.225% on import duty. You know, my message to this whole assembly are that the Ministry of Finance seriously frown at this. But now that the majority leader is proposing...
No, don't say the majority leader. Don't put it on the majority leader. Honorable, whoever decides whatever, the final decision is here.
For the committee, what the committee
and
decide...
you have to be informed.
No, Honorable Chair, I am standing by the committee's decision.
Yeah. So that is we delete it. Honorable, the committee's decision is we delete
That's
it.
what the committee said.
Yes,
But the majority leader can propose.
I'm appealing to the committee. You know, we're talking about security here. I'm coming. We're dealing with security. And this is their joint operation. There has to be a form to really do that. That is why I'm appealing. Yes, 0.25 might be on the high side. Let's try a compromise. So it says 0.15, 15%. That's my submission, Honorable Speaker. Thank you.
But Honorable, we have listed about 10 or 11 that they are going to be sourced from. Sourced from. No, that's the truth, to be honest. That is the truth. You know, I'm afraid when they tell me the Minister of Finance, why would the Minister of Finance say this? Because they have the picture. Yes, Honorable Minority.
Honorable, you remember I read...
He's talking about phone. The custodian of phones is advising you. If you care about lack of fund, the one in control is telling you that there'll be no problem. Huh?
It's playing politics now.
More on the floor.
Oh, no.
Yeah. No, but more on the floor now.
This is what we are reading.
You know, Chair.
What I'm saying is, for me, my stand is very clear. Because this is an issue of national security, and it must be prioritized. And what I want is, let's make sure that the funds will be available. And to do that, we must be able to tap something that is guaranteed. Now, even though the Minister of Finance doesn't like for us to touch the import levy, we all know that. But can we go down, just like what my majority said, at least let's reduce it to 0.15. At least we are certain that some money will be there.
Chair.
That is so. Why don't we put it under the budget? Why don't we appropriate funds for it? If it is as important as what you are saying, we cannot get funds for it.
Yeah, but then if you put it at the act, transfer to the budget.
Now let's put it to the budget, and then additional some things can come into the
Honorable Chair, once they have it in the act now, it's a legal base now for them to put in the budget now.
Pardon?
We are now putting it as an enactment now. Once they have it in the act now.
No,
I'm coming, Speaker.
No, what I'm saying is, but here we are saying it's here in the act, but we are saying it's to be funded only by this, not appropriation by Parliament.
I understand. What I'm telling you is that at least they know that this is what we are going to request from Minister of Finance, that according to our law, we should have like 0.15% funding from the import levy. Yes. Yes. The security. This security operation, joint operation. Chair.
Chair. Chair. Chair.
Chair.
Chair.
Talini.
Chair. Chair, it's me, Serakunda. Serakunda.
Talini. Okay.
Thank you very much, Chair.
So like I was saying, stop
Chair.
interrupting me. I'm giving the floor. Stop that. I'm giving the floor already. Stop interrupting.
Chair,
So, like I was saying,
my worry is that the joint operation is not interpreted in the bill.
you hear the
We
chair
need to
telling
know.
you. Why how can you interrupt? Stop that. No, stop that. He gave me the floor already.
Please, exercise decorum.
No, he said telling me. He gave me.
You are shouting. Let's
No, you are the one penetrating because he said telling me. I heard that. No. He said telling me.
Must be a misunderstanding. I wanted to talk to you, and then I heard Serekunda. I said Serekunda. Yes, don't worry, you come. Serekunda, go ahead.
So my worry here is that joint operations needs to be interpreted so that we can know their function in order to determine funds for that operation. Because there are so many, there is joint operation coordination committee here, no fund is needed. And I totally concur with what the member for Upper Salem said. Even the new recommendations, it states that a 5% of the revenues generated annually from insurance premium, notwithstanding the minister responsible for finance may vary. Already you are setting a percentage, and at the same time, giving the minister also to vary. This will lead to a situation whereby we are establishing an office that will be under-resourced. So we need to look at it.
Honorable, all right. Honorable Member for Kalindi.
Yes, Chair. I think we are belaboring too much on this because I want to believe I stand by what you have said. The institution that have the capacity, who are the custodians of the funds of this country, we've engaged them, they have guided us with regards to, and they are in agreement to remove these things. Now, with the enactment of this bill, this ONS will go into bilateral with the Ministry of Finance and see what is possible to any of these funding lines, even the joint operations. They will go on a bilateral and agree with finance. This is the fund that are going to be derived to put in this fund. So we have no worries with regards to whether the funds will be available. It's not going to be. The institution that is responsible guided us. We are going to tap these funds from this end, and we are going to put funds into this. So, Chair,
the funds will be available.
Yeah, the funds will be available, and they will be available. Let us not question.
Let's get somebody. Somebody's son was there first.
Thank you very much for giving me the floor.
Somebody was calling out there.
Chairman, nobody's calling, it's me.
Yes.
Chair, you see, we need to, how do you call it again? Do I say distinguish these two funds apart? The running of the office and the administrative fund, the salaries here and there, yes, each come from a ministry. We understand that. But what we are saying, this is about more of recurrent expenditure, operation of, the joint task force, the joint committee. You have to have, a steady flow of resources coming in to be able to do, and we are dealing with security related issues here. That is why I know the fear of the Minister of Finance is that 0.25% might be on the high side to maintain. But however, let's also go down and see even if we put the 0.15%, under the circumstances, if it cannot be obtainable, he can always advise. But there is no harm in maintaining that.
It's what we are saying.
Chair.
We heard you well.
I will go with
But what
Chair.
we are saying, Honorable, Chairman of the committee,
Chair.
Chairman of the same committee, you are saying that such reasonable amount of money is annually obtained from 1. National security levy, processing fees on sale of passport form, national identity card forms. That's all. Every day people are looking for ID card. No, these are facts. Alien form, every day, every second. Residence permit, a community form. Resident permit B, community form. Entry clearance form. Emergency travel certificate form. Entry visa form. Extension of stay form. Naturalization for community nationals form. Driving licensing form and learner's license form. These are almost everyday occurrences.
No, Speaker.
Honorable Speaker, these forms are just $10, $15. These are not the fee of the passport or the ID card.
Exactly.
It's just the cost of the forms we are talking about here. So this is not significant. It's a very tiny amount.
The honorable finance people, the custodians of the money, know what they are doing. They are the people who said this.
Honorable Speaker. Honorable Chair. These are not serious funds to run a security operations.
If a bill comes here, and then we have advice.
We are talking about $10, $5, $15
legal matters. To run from the AG.
Honorable Chair, I am saying, in my best opinion, those are not really serious financing to this bill. Because $10, $5, $15 form. Where is $10? I'm just saying, because if you look at the LS card, how much is it? Let's look at it. Thank you, $9. You understand? Somebody said that the form is $9. So, to seriously finance this thing, Honorable Speaker, I think I beg the intelligence of the committee of the whole House to really go in for 0.15% of the security import levy, please.
Honorable Speaker, having listened to all their argument, I think, we amended C, we can still add 0.15% of the import duty. We will incorporate what we amended and then add 0.15%.
Then does it mean that we are removing all other 1, 2, 3, 4, 5, 6, 7?
No, we are not removing. We are maintaining.
In addition to that, if they are not removed, let's remove them. But I'm saying,
Thank you. We are in agreement now.
No. This national security, each of these security, these are independent security agencies. Independent security. I agree. But security issue.
Security issue is very important.
You put there, if there is security, if you put it in Klabekela. Honorable members, now the whole thing has to be renumbered again. The proposal is that where is it? Where is the bill? This is the bill. So the report is itself amended. Honorable Chair?
Yes, it is amended to include, when you look at the report on C, now we are going to add last 0.15% of the national.
No. What we are saying, Honorable, the bill, if you look at the bill, one is A is there, 3A, 3B, we are going to leave 3C there.
Exactly.
Yes. Now that 3C will now read 0.15% of the national security this thing. Do you understand? So 0.
Chair, on the report,
yes,
what we have on the report,
yes,
and then at the last of C, we will add 0.15 of the national security levy on import duty.
On your report, you mean?
Yes.
On the report you have removed this thing.
Yeah,
you have removed C.
Yes.
All what you need to do is in your reporting now, honorable, on your report, where is it? On your report, just put 1AB, then the C that you numbered as 3. The C, on your C you have national security, national ID, etc. That will go back to its 4. And then you put that to D, and then that C becomes this one as it is. I don't know whether you follow me.
Now you want us to see what we have on the report to form part of B?
Yeah, your report, in your report, you removed the whole of C on the bill. Now you want it included.
Exactly.
So A on the report is A on your recommendation. with slight amendment.
Yes.
B on the report is B on your district with slight amendment.
Yes.
C on the report it should be C on your recommendations with slight amendment.
Yes.
D on the report will be D on your district without any amendment.
Yes.
Finish. That's what we are going to have.
Yes. Yes. That's what we said.
Yeah. That's
what you have C on our report, and also the 0.5 will be added. 0.15.
No, no,
Yeah,
Honorable Jai.
no.
Honorable Speaker, with your permission.
You know, you are removing C, just like what you did for A.
Yes.
A, you remove the whole of A of the bill, and you replace it with that one. So C also, you are removing all that, replacing it with 0.15%
Yes.
of the national security levy on duty import. That's all.
No. What I'm saying is, so you are proposing that we delete C on the recommendation and reinstate.
No. What I'm saying is, your number C on your current recommendations, it should now be D.
Oh, okay.
And then you should
Yes. Agreed.
C should be the ones you have.
Agreed.
Yeah. Yes.
Now I understand.
Somebody is shouting. Yes, please.
Now
That's
that
okay.
the finance minister is not here.
That is okay.
Hey, all right. The finance minister is not here. The levy on import duty, whether we have other entities or agencies or institutions that are benefiting from the levy on import duty. That's a question that I want to ask. I'm not sure whether the ECOWAS is pending. Oh, yes. So with this percentage, it's minimal.
Yeah, it's 0.15, not even 1.
No, in huge amount, percentage-wise, that is a big money.
Yeah, it's a small percentage though.
Yeah, it's about when the amount is on high side, it can generate a lot of money.
Yeah.
Yes.
Just to help, Chair, if the import levy is, if it is approximately 5 billion, for example, 0.15 will be about 75 million. So it's not that much. It's about 75 million. So it's not even 1%. So it's not that much actually.
Yes, we are fine as we propose. Yes.
C and D.
Yes.
Only the A is amended to that.
Yes.
B is amended to that.
Yes.
C is amended to that.
Yes.
Honorable members, we have all had it. So, who is asking? Opasalu.
Yes. On 5, I see that they're saying the Accountant General shall manage the fund.
No, we have amended. We'll get there. Let me read. Let me read on 5.
Huh?
We've amended it.
Yeah, we have amended it. Our amendment on 5 reads as follows: that the office shall manage the fund instead of the Accountant General.
That's the office of the National Security Council. The proposal is the Accountant General instead the office.
The office instead of Accountant General. Proposal is office instead of the Accountant General.
Yes. So, honorable members, you know we have all had the proposed amendments. It is read out to you, and we have agreed. And now I am putting the question on 21. It is proposed that 21 National Security Sector Joint Operations Fund stand part of the bill as amended. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
No.
Clause 22.
Yes, go ahead.
No.
Clause 22 under part 7 of miscellaneous provisions. Clause 22, confidentiality.
No issues. Yeah, you remember we talked about the numbering, wherever it occurs, the numbering, but no issues.
Sorry, in fact, on 21.6, you are recommending that we remove 6.
No.
Yes, on your report.
We are going 21. Yes, 21 on 6. But we have voted on the...
Without prejudice to subsection 2, the accountant general shall release the monies. That one should no more be there.
Yes, that one is normal on 6, 21.6.
Report said that it shouldn't be there. It's already in the report.
Yes, it's removed.
We are going by that.
Billy, yeah, we are deleting 6. Yes.
Suppose that clause 22, confidentiality, stand part of the bill. Those in favor, please say aye.
Aye.
Those not in favor, please say no. The ayes have it.
Clause 23, authorized disclosure of information.
Proposed that clause 23.
No issues.
You have something?
No.
It is proposed that clause 23, authorized disclosure of information, stand part of the bill. Those in favor, please say aye.
Aye.
Those not in favor, please say no. The ayes have it.
Clause 24, non-disclosure of documents before the National Assembly.
We have.
You have.
Yes. We are recommended that clause 24(1) and 2 is recommended to be amended by substituting it for the following.
Go ahead. Read it.
Yes, it reads as follows. 24(1). Where the president or any member of the cabinet satisfies that the disclosure of the contents of any document sought by the National Assembly or Committee of the National Assembly from the Office of the National Security will be injurious to the public interest or prejudicial to the security of the state, the National Assembly or such committee shall only give consideration to such document in private, and under such conditions as it will prevent the disclosure of the contents of such document outside the National Assembly or the committee, as the case may be, shall not publish the document or its content.
24.
Yes. As enshrined in section 119 of the Constitution.
Honorable members, you have seen the proposal.
Yes.
Against what is there. Yes. Yes. Table care of committee.
Sir?
The injurious, third line.
Yes.
Injurious.
Yeah, it should be injurious, typo.
Yeah, you know that and it should be corrected.
And in fact, it's injurious, but I read it as injurious. I have not even realized that it's wrongly spelled.
Yes, honorable members, it is proposed that clause 24, non-disclosure of documents before the National Assembly, stand part of the bill as amended. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 25.
Hold on.
No, unless the numbering, as I said, no amendment. The finished chair will go back to clause 8. We'll go back to clause 8.
Clause 25. Privileged information.
It is proposed that clause 25, privileged information, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 26, regulations.
It is proposed that clause 26, regulations, stand part of the bill.
No issues, only the numbering.
Those in favor, please say aye. Aye. Those not in favor, please say no. The ayes have it.
Going back to clause 8, page 8.
Mr. Speaker, I move that we rescind our decision.
Just hold on. Clause 8.
Now, clause 8. You remember, Chair, are you there?
Yes.
Now we are maintaining the Chief of Staff.
Move a motion to rescind our decision first, then we can insert the.
On what?
The title, Chief of.
No, it wasn't voted.
It wasn't voted. It was not voted?
No, I think the executive director.
What we had, executive director, that's what we put there before. That's what
No, we did not vote on it. You know, we were arguing. Then we
voted on it.
We voted on it. It's amended in my book here.
No.
We talked about the chief executive officer. We talked about the executive director.
Exactly.
We now agreed on the executive director.
No, I think we agreed to come back.
Yes, we can go back on it.
It was not voted.
We agreed to go back. Don't agree. We can go back. So, what are you proposing now?
We are proposing Chief of Staff.
Honorable members, clause 8 of the bill. The original specification heading is special assistant. It should now, as agreed, as proposed, read chief of staff.
Yes. Yes. In the military is always that.
Chairman, the chief of staff aware. Chief of staff.
No. Let's be.
Office of the National Security Advisor.
Good. Honorable, just give me a chance. The heading is chief of staff.
The National Security Advisor.
Huh?
Chief of Staff.
No, the heading is what we have here is chief of staff.
Yes.
Or you want us to add something to it again?
It's okay like that.
Chief of staff. Because we used to have the special assistant.
No.
Yes.
Now we have Chief of Staff.
This is what I'm saying.
Yes.
Now it says the special assistant A1. The special assistant should now read the chief of staff.
Yes.
And wherever it
appears.
It appears. Isn't
Yes.
it? Honorable members, are you following?
Yes.
Yes. Under the special assistant to who?
Now, no, the special assistant is now Chief of Staff.
I mean, the special assistant to who? The chief of staff to who?
To the National Security, Office of the National Security Advisor. Office of the National Security Advisor. Of the National Security.
Honorable Speaker.
Or National Security Officer.
Chair, Honorable Chair.
I'm getting confused.
The title is the Chief of Staff. That's clause 8.
Yes.
1 will read the Chief of Staff of the Office of National Security.
Exactly.
1.
Chief of Staff of the Office of National Security. Is the vote control of the administrative.
All right, honorable members. Whereas we are going to have it is proposed that we change the special assistant to chief of staff, but on 1, it should be the chief of staff of the Office of National Security.
Yes, Chair.
Of the Office of So, you know, wherever you have this special assistant, it should be chief of staff, huh? All right. So we are now fine. Do we put the question? Do we receive the question?
I move, Billy, yes.
Pardon?
I move that we rescind our decision on clause 8.
Any seconder?
Seconded.
It's moved and seconded that we rescind our decision on clause 8. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. It is proposed that clause, read.
Clause 8, Chief of Staff.
We are going to read is the special assistant.
Special assistant you should
We
read.
are going to read.
Clause 8, Special Assistant.
It is proposed that clause 8, special assistant, stand part of the bill as amended. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. Honorable members, we now come to the end of the committee of the whole House. The House will now resume the House. Honorable members, the House now resumes. Honorable members, the third reading of the National Security Council Bill 2024 is scheduled for Monday, 29 September 2025. For His Excellency, the Vice President, to move for his third reading. However, before this date, the Office of His Excellency, the Vice President, is hereby urged to comply with Standing Order 7220 to ensure that the amended version of the bill is printed and circulated to members in advance. And once again, I thank the Honorable Minister, Attorney General and Minister for Justice for ably assisting us together with your technical backup. Honorable members, yes, I'm coming to you. Honorable members, what do we go out for a break? Because we have two more bills to come. Yes, Clerk, Majority.
Yes, thank you very much, Honorable Speaker, for giving me the floor. I think it's apt for us to break and come back at 4:30 for lunch and prayers.
But before we go out on break, we have a proposed motion from the Honorable Member for Bikaman North and the Minority Leader.
Thank you very much, Honorable Speaker. Honorable Speaker, I stand on order 53K. That is motion agreed by the Speaker to be a matter of urgency, and also standing order 103.13. It reads, with the exception of the Assembly Business Committee, and except by leave of the Assembly, no committee shall sit while the Assembly is in session. Honorable Speaker, with your permission, the FPAC wants to meet tomorrow by 10 a.m. to engage the Attorney General, Minister of Justice, on the current happening at the National Office. With your permission, thank you. National Audit Office.
I rise to second the motion, Honorable Speaker.
It is moved and seconded. Yes. I mean, the honorable member, please. The honorable member for Brikaman North and Minority Leader moved a motion that they were supposed to meet the Attorney General tomorrow on the Auditor General's issue. Am I right? The current, and therefore they want permission from the chambers here for them to be excused to have that meeting in the morning. Yes, Honorable Majority.
Thank you. Before you put to vote, you see, already we have a committee, a special committee sitting, and you want also the FPAC to go and sit again, we may like to have quorum. So please, I think we already have a special committee that is already sitting, and we want the FPAC also to come and sit again. We are likely to have quorum. So we'll indulge with them to allow us probably by next week. Probably by next week, we can allow you to sit and engage. So please, can you bring the motion next week so that we can allow you to sit? Thank you.
Honorable members, I have said this. No honorable member, no amount of shout can you prevent another honorable member from speaking. So let's listen to each other. If you have a different idea, when he's ready, raise it and you'll come out, we will listen to you. But if somebody is talking, you want to prevent him, you are only wasting our time because you cannot prevent anybody from talking. Please. Huh?
Yes, thank you, Chair, very much. In as much as we understand what the majority is trying to say, but let's remember 2 of the members in the special committee are also in FPAC, so it won't have any impact. So we can still meet, and it will not affect what we're going to do at the special committee, and we're not going to do what we do at the FPAC. So quorum will not be an issue.
Talinding. Honorable Member for Talinding.
Yes, thank you very much, Honorable Speaker. I want to thank the FPAC, members of FPAC for this. When crisis or situations that can result into crisis happen, National Assembly must do its job. And I think this is very important they engage and find a way out. Thank you very much.
Assembly allows them to sit tomorrow to meet with the AG. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. Pardon? Division. All right, now get your tax ready. Get ready. Those who are in favor of the motion, raise your tax. Those in favor of the motion. Those not in favor of the motion now raise your tax. Huh? You got it? Now. Are you ready? Honorable members, honorable, the results, the ayes, 13, the noes, 3, abstention, 1. So the ayes have it. We are now going out for a short break. Is 15:40 by my watch. For how long do we go for break? 1 hour.
Yes, 1 hour. Lunch and
All
prayer.
right, we come back by 15:30.
14:30.
14, huh?
14:30. 14:30. I mean 16:30 rather.
Yeah, 16:30.
16:30. Yes.
Yeah, but that is more, very near 1 hour, see, Alaji. Alaji, and Alaji, you will come after the break. Honorable member, so we are adjourning probably until 16:30, 4:30. Huh? So the house now stands not adjourned. Not adjourned. Huh? Suspended. It now stands suspended until 16:30.